It is in the list. Oh,
It has item number 1.
oh, I am sorry.
My lord, may I have your lordship's kind leave to mention?
এটা কোথায়? এ আসেন? Give me a second.
My lord, my lord.
ওই এটা আসেন।
My lord, I may be
Expiring?
15th, the day after tomorrow.
Sir, why so early?
Because
Huh? 15th May, how the matter?
I will try my level best to get. Kindly make it.
দিয়ে দাও ওটা যাও দাও ফাইলটা
My lord, my lord, with your lordship's kind leave, my lord. My lord, yes, my lord.
Motion matter, just hand over the slip.
My lord, new motion. I have
New motion, just hand
My
over
lord,
the slip.
twice I have mentioned file also came from the department.
It will be listed, sir.
Yes,
If
yes.
you have file, it will be listed. Let me proceed in my own way.
Also said from the
Only, my lord, yes, my lord. Sorry.
Here.
Yes, my lord.
Motion matter, new motion matter, hand over the slip.
Urgency, my lord, if you kindly see. New motion only, I am submitting.
Any new motion matter?
lordship mentioning for restoration.
Motion matter I want. Yes, sir.
My lord, an extremely urgent matter, my lord. I beseech to move tomorrow, my lord, before your lordship. My lord, in this particular case, my lord, we are the owners of 69 acres of land. My lord, worth crores have been invested to purchase this property. Now, my lord, your lordship will be shocked. My lord, the revenue officer of the West Bengal Land Reforms Act, my lord, very recent.
You want upgradation?
No, my lord. My lord, I want, my lord, for hearing, my lord, tomorrow, my lord. What has happened? I'm telling your lordship, my lord. Why, my lord, I'm telling your lordship. My lord, why I'm telling your lordship. No, the revenue
Don't
officer.
make any unreasonable-
No, my lord, I'm not. My
Sorry.
lord. No, my lord, I'm beseeching your lordship for upgradation, my lord. Why?
The
But why
court's diary is already preceded.
Absolutely, my lord.
I
Not only one, my lord. Why I'm seeking your
I
lordship's leave, my
cannot
lord.
give you any precedence, sir.
My lord, only one.
Sir, court is convinced not to be convinced. I'm sorry.
My lord, only one effort, my lord, is that the order has been passed.
Listed land matters which is listed prior to the change in the determination manner. After the
New motion.
yes, listed motion, new motion.
Hand over the slip.
But it's not coming on. It's a repeated mentioning, my lord, before my lord.
Sir, let me do in my own way. I have some limitation also.
Matters have been sent down to the department. After the change in the
By me.
no. After the change in the
It will
determination,
be listed. Let the file come.
Then it-
Yes.
kindly understand our
My lord, I may be permitted to mention one item, my lord.
No, no, এটা এমনি দিয়ে দেবো।
So why are you so early in mentioning?
I mentioned repeatedly. before
File
my
আসছে না?
I repeatedly mentioned.
Very good, sir. I shall
But then
see.
may I only beseech for inclusion?
To mention item number
Inclusion.
84 of
Wait,
the
wait.
combined list, my lord. 84 of the combined monthly list, my lord. This is, my lord.
Sir,
the
your,
petitioner
your,
not
your
getting
brother is
compensation.
mentioning. Sir, I cannot follow.
Item number 84 of the combined monthly list. I'm mentioning for upgradation, my lord.
Upgradation not possible.
My lord,
Yes.
this is, my lord, for
Be there
compensation.
as it may, we have to wait.
73, my lord, I am prepared not today, my lord.
Wait.
For restoration, land matter.
Restoration ওটা দিয়ে দাও নেক্সট উইকে যে কোনো একটা দিনে দিয়ে দেবে
Let it be given for inclusion then, my lord. It's
Yes, ধন্যবাদ দিস বাই সালসি
Yeah, deeply.
আমাদের ডিটারমিনেশন নয় তাহলে ফেরত দিয়ে দিন if it is not within our determination then don't give.
May I be permitted to move this application as an urgent unlisted motion, my lord? Because urgency is this, my lord.
Everybody has urgency.
My lord,
File
urgency
it.
is this. Kindly hear me for a moment. My lord, the irrigation and waterways department, my lord, digging the canals, my lord, without following the process of law.
It will be
My
taken
lord,
care of.
my
Hand
lord,
over the slip I shall see.
Petroleum.
Lordship,
my lord, may I take leave?
Hand over the no leave. File it in accordance with law. Yes.
So I have mentioned this matter, Lordship, file has come. Lordship, let this matter be appear in the daily supplementary list.
It is under the heading.
Motion file.
Motion I shall see.
Lordship,
It will be taken up in seriatim, sir. Sorry.
My lord, I may be permitted to mention one item, my lord.
Wait.
Lordship, 2024 motion till date I have not chance to move this, sir.
Very good.
Since 24 it
I shall see. Any other mentioning?
daily supplementary list.
Any other mentioning?
I want to mention for non-prosecution, your lordship.
Dismiss for non-prosecution.
Your lordship.
Hand over the slip, file টা আনিয়ে নাও নেক্সট এই উইকেই ভালো যদি হয় না নেক্সট উইকে আনিয়ে নেবে
On matter for inclusion, hearing.
হিয়ারিং ম্যাটার উইদিন মাই ডিটারমিনেশন কাইন্ডলি হ্যাভ ইউ সার্ভ নোটিস
Yes, earlier occasion I have served
নো সার্ভ নোটিস দেন কাম
I have earlier occasion served.
সার্ভ নোটিস দেন কাম ইয়েস ম্যাডাম
My lord, this is a port blur matter. My lord, my senior Mr. Gopala Binukumar appears in this matter. There is an extreme urgency, my lord, as wide order dated 25th of January 2025. The authorities have imposed a fine upon the petitioner for an amount of rupees 3 crore 86 lakhs and odd. And they have seized my stone aggregates and river sands. With the all things are done without jurisdiction, my lord, and without giving any opportunity of hearing to the
In the
petitioner.
month of June, the circuit will be available, no? In
My
the
lord,
month of June,
that will be
circuit will be
available in the
available.
month of June. By that time, they will
We
recover
are
that
now,
amount,
we
my
are,
lord.
we
There
are
is extreme
now,
urgency. We are seeking for an interim order. Uh, I'm praying, my
in
lord,
the-
let the matter be listed tomorrow, my lord.
wait for a fortnight.
My lord, let it be listed tomorrow, my lord. We are seeking for an interim order. There is an urgency, my lord.
It is within
huge
my
amount-
determination. It is within my determination.
My lord,
It is within my determination.
my lord.
Pursuant to order passed by me.
No. This is not a contempt matter, my lord. I am
It is
an
a new
enlisted
matter. It is a
new
new
matter.
matter within my determination.
My lord.
Hand over the slip, I shall see.
My lord, we have already filed it in Port Blair, my lord. Let the registry may be directed to transfer the file through mail, my lord.
ফাইলটা আনিয়ে নাও তো।
My lord,
File টা
grateful,
আনিয়ে
my lord.
এটা দেখে
Madam,
নাও। ফাইলটা
mentioning-
আনানোর পরে আমার কাছে নিয়ে আসবে।
For withdrawal to file afresh, the matter is appearing in my.
Where is your slip?
My lord, I'm mentioning some Port Blair, my lord.
That I've understood, but how I'll get the slip? Mentioning slip? E-slip or something like
I
that?
will submit, my lord. I'll send somebody to submit the slip.
What is the procedure? এটা কি
My lord?
procedure? Wait, হ্যাঁ? না ওনারা তো একটা কিছু পাঠাবেন। সেটা তো থ্রু মেল তো কিছু পাঠাতে হবে। You have to send a soft copy of the mentioning slip to my SEO.
My lord, I will send through mail, my lord.
Very good.
Mentioning slip.
Send it.
My lord.
Send it.
My lord, obliged.
What is this?
My lord, I'm mentioning for withdrawal to file afresh, the matter is.
এটা কি আমার determination আছে?
My lord, appearing today's list item number 60. Today it is appearing as item number 60.
60?
60.
You want to withdraw?
Yes, for filing afresh, there is some typographical error in the read petition. Today it is appearing. for
তাহলে
the-
এটা আগামীকালে to be mentioned দিয়ে দাও। Under the heading to be mentioned. Any other mention?
Quickly oblige. There is a new motion, my lord. My advocate on record has only handed
Hand
over
over
the
the slip, hand over
only
the slip.
notice of my lord mentioning. I'm giving the number, my lord. They already been mentioning the notice of mentioning, my lord. In the email, I'm also giving the number.
Give
My
it.
lord, may I have your lordship brief to mention a motion, my lord?
আমি হ্যাঁ
Motion just hand over the slip, sir.
আমি নতুন এটা
Well, in
Come on.
regard
আমি
to
তো
item was 73, my lord.
Sorry?
73.
Is the other side present?
No, my lord.
Then how can I take up?
Well,
In his
not-
absence.
Not today, my lord. Only praying for not.
Even for accommodation, you have to give notice. Ask any of you, if you have got some difficulty, I can understand.
73, my lord.
We, in absence of your other side, how can I take up the matter? What is the item number?
73, my lord.
72.
73.
It is an application matter.
Application matter. Well, only not today, my lord.
I shall see. If you will not be present, ask any of your friends to mention, I shall consider. Yes, call the list.
This Axis Bank matter, Lordship had directed that page 37, if your Lordships kindly come. Page 37 of your Lordship's order.
Yes.
Towards the bottom, the committee shall also give an opportunity of hearing to the writ petition number 2 and the authorized representatives of the others. So, my lord, I am praying not the writ petition number 2, writ petitioners and or their authorized representatives.
Physically handicapped person.
Absolutely correct, Lord. So instead
Acho.
of writ
interim order.
Item
The
2,
interim
Lordship,
order is expiring on 15th, my lord.
Lordship, may I beseech Lordship kindly fix the date. It's a very short matter because the lease has expired immediately after reopening, subject to convenient to your Lordship. Kindly fix the matter. It will not take much time because the petitioner was a lessee whose lease has been expired due to efflux of time. The petitioner has alleged that in spite of making penalty, he was prevented from 7 months from extracting sand. That is
Have
the
you,
issue.
have you, have
Lordship,
you
state has filed a report.
report?
Yes.
We have filed our exception, my lord. My lord, this is my
It's
exception.
a very short issue, Zilbab. Lordship,
Exception we
kindly
kept on
fix the
record.
matter. I have today for extending of interim order. Lordship, I am standing in the way.
দেখি আছে।
And kindly place the matter immediately after reopening.
The exception to the report, in the form of affidavit as filed by the respondent number,
No, petitioner.
the exception to the report of the respondent number 6 as filed by the read petitioner is taken on record. Stop. It is submitted on behalf of the read petitioner that the interim order as passed earlier is going to expire on May 15, 2025. Stop. In view of such, the interim order as passed earlier is extended till the last day of June 2025 or till further order, whichever is earlier. Stop. Let the matter be listed on June 20, 2025 at the top of the list with the marking that the instant matter will be taken up after hearing of the motion matters in original site
No,
on the said day.
I'm grateful.
Friday I take up original side matters. After original side matter I shall take up this matter.
Good.
এটা আন্ডার দি হেডিং বলে দিয়েছি, হ্যাঁ আন্ডার দি হেডিং এটা রেখে দেওয়া হচ্ছে ওই মোশনে রেখে দাও। নেক্সট
No.
why it is listed under the heading for order, sir?
My lord, the matter was initially heard by my lord Justice Aniruddha Roy, and there was a direction, my lord, to file my lord report explaining the thereafter, my lord, subsequent development, my lord, during pendency of the my lord instant writ application. My lord, the matter relates to my lord. I am the my lord lawful owner of a my lord the plot.
তুমি নোটিশ দিয়েছিলে?
Stop, everything.
কাকে নোটিশ দিয়েছি?
আপনার জুনিয়রকে সব দিস
তো ওখানে
everything has been
নাম্বার আছে? নাম্বার আছে? সেটা আমার ক্লার্ক করতে পারে।
the petitioner, my lord, the
Well, I'm a bit handicapped because my brief junior is not here. So I don't know whether report has been prepared or not.
twice, my lord, the
Though
my
my
lord,
learned friend has given her notice,
not a single time, my lord.
Who is
Twice,
the
my-
respondent number 4 here?
respondent number 4, my lord, the block development officer, my lord.
ক্লার্ক আছে? ক্লার্ক আছে? জানেন?
No.
নাম্বার এই নাম্বারে ফোন করতে
Block development officer, my lord.
What is Madam Priyanka Jana? A report has been received from the department that no report has been filed to the respondent number by the respondent number 4. What is the application for addition of party?
My lord, addition of my lord, during pendency of the my lord, this writ application, my lord, without সবই দিয়েছি বলছি সবই application for addition
I'm not blessed with the copy of the application.
application everything has been served, my lord, kindly দেখো
বুঝতে পারছি তো আমি কি করবো?
From the affidavit of service as filed today is taken on
My lord, in the meantime, any steps, my lord, my crops are standing like, my lord, they are, my lord,
Very good. On that day, I shall consider.
my lord, that also.
4 who is appearing?
Though it is the first time, my lord, in pursuant to your lordship's direction, my lord, KMC authority has not done anything. Though, my
Where is
lord,
my order, sir?
yes. Page 17, my lord, kindly have a look. The portion, paragraph 11.
এইটা একটু উকিল বাবুকে দাও তো ফাইলটা। Kindly open page number 17, sir.
Oh, sorry, my lord, not page.
Make pagination.
Question, pagination
Make
গুলো-
pagination. First make pagination.
pagination গুলো করেন না কেন? এ তো মহা মুশকিল তো। জজ সাহেব, ভগবান।
Call the next matter, it will pass over.
And next matter also my matter, my lord.
Paginations are complete, Mr. Poddar.
I don't know.
Kindly check, then it will be taken up. 4, 5 not today. Ask your junior not to be so casual, Mr. Poddar.
Sorry, my lord.
4, 5 not today.
My lord, 6 I am for the petitioner's matters, identical matter, lordships you have heard in Mr. Choturvedi was there. That's the identical matter, that copy I have got. So
Very good.
this is the same, just lease deed date and impugn order, like
Have you
application will be changed. That has to be changed. If you lordship please, then I make it correction. It is identical matter. Then I'm just now I'm just make it current.
ওদের এগুলো চেঞ্জ করে দাও।
I'm changing it. Lordship.
না হ্যাঁ
Able to do it. Sure. Hey, copy দিন।
কপিটা দিয়ে দিন দাদা।
অর্ডারের কপিটা দিয়ে পেন্সিলে
Pencil mark করে দিন। I'm doing it. No,
Yes,
Lordship.
yes.
I'm just changing it right now. No, I can't do this.
only the date of application, lease deed. Yes.
Lordship. I'm doing that by 12.
12 o'clock? 12 o'clock?
শুধু সবই থাকবে, শুধু এইটা চেঞ্জ হবে। হ্যাঁ।
Sir, take your time. Don't make any hurry. As otherwise, again, you have to come and I am to make an order for correction.
I am for the state respondent.
7 who is appearing?
I am for the state respondent.
In this matter, my lord, I am led by Mr. Shubhir Shandal, senior advocate. Kindly grant a short passover, my lord.
Passover is not possible.
My lord. Yes, come.
লিখে দাও ফাইল দাও। Item number 7.
Lord, may I take your leave, to your lordship's leave, to file our exception to their report. Lord, I tell your lordships, we may be.
Give me a second, Mr. Shandal.
গোটা জায়গার মধ্যে কতটা নিয়েছে।
Yes, Mr. Shandal.
Now I tell your lordships, I may be at the mercy of your lordships, but what I want before your lordships, let them act according to law. I tell your lordships, I am a food grain carrier of a food corporation of India. I have my own property. Well, there are government cars and trucks, your lordships, that loaded trucks are to be parked. Now there is a huge land beside me. I have wanted them, the government, give me a long-term basis in a lease on according to law. That's our main prayer. Now, my lord, after hearing this, a report was called for from the government. We have been, my lord, recommended by at the lower strata of the government, your lordship, that this can be done. Now,
How a read court can ask the government.
I'm not asking them to consider according to their scheme. Scheme says if it is a the commercial purpose, then has to be auction. Let them auction, I will participate. That's I tell you, losses out of the huge land.
What is your representation?
I tell you, losses. I'm not saying that I have to be given. Well, several representations I have made.
What is your last representation?
Last representation, I take your lordships to page 62 to 67. Recommendation. 56 recommendation. That's okay. 56. 65 your losses can take our representation. 56 your lordships will be page 56 your lordships will be getting the recommendation that this can be done.
$65.
56. 65 is my last representation in detail. At page 65.
What is LTA stand for?
Long term.
Long term?
Settlement. I will take your losses to the scheme. I have annexed also. They have annexed, not in full.
No, the land which is situated beside your property has been wasted.
Wasted, admittedly, my lord.
Then what do you want?
I want long-term lease, my lord, settlement on the basis of the scheme of the government. So the government stand on the report that this is a commercial venture. It would be auction. Let them auction it. I will participate. If I get it, I will get it. When somebody comes honestly and pays for, they show their scheme. But when somebody get it, otherwise.
What is the report?
First your losses kindly come to page 56. Then I will take your losses to the
page number 56.
56 of the writ petition.
Yes.
Well, kindly see this is of dated 16th September 2017. Petition submitted by such and such, measuring area 8.84 acre under such. In sending here with the petition submitted by Sri Sandeep Bonik for grant of LTS of Government of India in plot number such and such, measuring such and such acres under PS Bata, he is requested to inquire the availability of government vested as prayed for by the applicant and send a detailed report along with sketch map and copies of ROR for further course of action.
Yes.
Now, because of this, my lord, this honorable court wanted report from the government. My lord, kindly take up their report. My lord, page 2, paragraph 3 is the report, my material portion of the report.
Page number?
Running page 2 of the report.
Running page 2 of the report.
They have filed, I believe.
Yes.
Running page 2 of the report. Yes.
3I. Well, kindly see, the scheduled land is under district Purbo Badnapur, block Vatar, Mauja such and such, plot such and such, area 8.84 acre. The same is vested to the state and currently is recorded Khotian number 1 is collected. Malad, we are not disputing, this is absolutely right. Page 2, paragraph 2, next page. One Shomik Bonik, the petitioner, before the Sahabanga 2 Panchayat, he claimed he is the owner of Rayati plot, which is adjacent to the current implumed plot and used as his Rayat plot for business purpose, for expansion of his business and for use of the shoot plot, which is under the disposal of the state of West Bengal. He prayed before the Panchayat Sabhagan 2 to issue necessary recommendations such and such. Then your loss is Roman 3. The additional district magistrate, district land instructed BLO to inquire availability of the said land. Kindly see, my lord, what happens now.
Yes.
Then your lordships, paragraph 4 reiterates the same thing that I wanted long-term settlement. Roman 5, page 4. the executive officer of Bhatar Panchayat Samiti and sent one's correspondence to block land reform officer regarding identification of one khas land from each Gram Panchayat, which was required for implementation of decentralized SWM within Bhatar Panchayat Samiti on exigency basis. Malad, only 2 dates are relevant. Kindly look at Malad, our representation date 1st 2017. When I Malad interfered in the matter, look, this should be given. Government proposed for me, then this proposal after 5 years comes from the Panchayat Samiti, so that I cannot get it. But even then, I'm allowed it, I can be considered I am showing your losses. Now your lawsuit, paragraph 6.
No, from page number 3,
Yes.
clause 2, it will reveal that you submitted your representation in the year 2007.
Yes, but it is going on. Even your losses kindly.
Now, sent a correspondence dated such and such, identification of us which was required for implementation of decentralized SWM. Then what happened?
Then your losses kindly. Paragraph page
May not
5.
be transferred to private party, and the same is future development which will be taken by the
Exactly. Malad,
Then
without the Malad interfering with any development of the government. Now, presently, your lawsuit, Roman 7. Presently, the same land had been decided to be used to implement a project of the government, namely solid waste management. The government of West Bengal, as a matter of policy, has decided to establish solid waste management program in rural Bengal in bringing the positive change in the quality of life in the villages by promoting cleanliness, such and such. But 2007 probably did not wake up to do this development. After my prayer, they have. Now that's okay, your losses. Now Roman 8, last 2 lines. Work order has also been issued for construction of segregation and storage cell of SWN project at Orgram. Then plots of land which the applicant has paid for long-time settlement cannot be given on long-time settlement by AL and
how the
AL
court can interfere with the
not your losses. I can, if I can satisfy your losses, court can interfere to this extent. Consider my prayer in terms of this scheme. Your losses can do that.
Sir, after obtaining this report.
Yes, your losses. I am showing that your losses.
This is a policy decision of the government, sir.
Policy is the scheme. Now, if somebody applies under this scheme, that has to be considered without violating any of the terms of the scheme. That much I can pay for as a citizen. And I am doing also as a part of the government function. I am a carrier of the food grains of the food corporation. Now your loss is Roman 10, 9. The plots of paragraph 5, your loss. I am taking each of the lines, your losses. Page 5, Roman 9. The plots of land which the applicant has paid for long-term settlement cannot be given on long-term settlement by AL and ALRO and R department, as the same has already been decided to be used for solid waste management project, which is purely for the purpose of disposal of solid waste, which creates environmental hazard. Now, Roman 10. Moreover, as per the land allotment policy, kindly see along, no land can be settled. This is the ultimate malrupture. No land can be settled on lease without inviting auction if the purpose is commercial. Now, my lord, out of 8.8 acre, leave aside the land required for the solid waste management. The rest can be done, your lordships. It's lying idle under this scheme. That I am showing your lordship that can be done. Kindly take up your lordship. They have annexed the scheme but not in full. Kindly take up our exception. Lord, kindly take up page 6 of our exception. Has you got that one? This is of 26 December 2012. Pay para 3. Now the governor, after careful consideration of the matter, is pleased hereby to make the following land allotment policy, which will be applicable to land owned or held by any department of the state government or agency funded by the state government in any manner. Clause 1 says long-term lease not exceeding 1990 years can be considered. 2. It can be lessee under the lease granted by the government or parasettles cannot mortgage. Probably that cannot be mortgage. Can mortgage with the par permission of the, that should be, my lord, if given, that would be one of the terms. Now, your lordship, vital is Roman 3, III. The Land and Land Reform Department is the nodal department for interdepartmental transfer of land and long-term lease of vested and khas land. An interdepartmental committee under the chief secretary would handle all cases of the departmental land transfer. The valuation for LTS would be based on the sale deeds of the area and the market price as determined by the Inspector General of Registration, Government of West Bengal. I'm accepting that. Then, your lordship, Roman 4, land made for commercial use shall invariably be auctioned to the highest bidder. But if I now can show your lordships that out of 8.8 acre huge land was already earmarked for the solid waste management, the rest cannot be given. Government keeps in his hand even after granting lease long term to cancel the lease. Government can earn money rather from idle land. Your lordships will find.
According to you, who will consider then?
That's your lordships, Roman 3, your lordships kindly consider.
Roman 3 of?
Roman 3 of the policy. Land and Lands Reforms Department. Your lordships kindly direct the Secretary of the Lands and
Roman
Lands.
3 of the policy.
Policy, page 6.
Land and Land Reforms Department. Then who is the appropriate authority then in the as per the
writ petition, your lordship?
District Land and Revenue is the authority to grant long-term settlement.
respondent number 6?
Yes, he is the authority whom will grant long-term settlement.
Let us consider.
Very good.
Only one thing I also say, to conscience, clear the conscience of the court. Kindly take up your lordship's page 3 of the exception. Without affecting any interest of the government, that the government can earn money.
Page 3.
In a lawful manner. Page 3, paragraph 6.
Yes.
But kindly see the middle paragraph of that.
Yes.
I further state that there is no dispute that the implementation of the solid waste management project is necessary for bringing the positive change in the quality of life of the villagers by promoting cleanliness, hygiene to protect environment. And as it appearing from Annexure R2 of the said report, the letter dated 11th October 2023 issued by the executive officer, Bhatar Panchayat Samiti, a land measuring about 6 kata was used. But can we also beat it? Out of 8.8 crore, let them keep it 4 times more than that land.
Very good. Let them
That's
consider.
your loss.
Let them come. You have to direct them to consider. We have nothing to say.
The
That's the scheme also. I'm saying it because I'm
Who will consider?
two first. If he rejects, then nothing. If he allows, then proposal will go to the DM. DM will malad execute.
Very good. কি লিখলাম বলো তো?
But what we allow, my lord, they let them, my lord, the
I'm not,
auction will be
wait for,
quoted and they will participate in the auction, my lord.
That's your law.
That's nothing, my lord.
matter.
I am filing the evidence.
Yes.
My lord,
Yes.
the land of the
Any
petitioner.
private respondents are there?
No, no.
Only state.
Yes.
State
state
Only
and
state.
Railway
railway
authorities.
Railway authority.
My lord, the land of the petitioners is situated adjacent to the railway line, within 30 meters within railway line.
Hmm.
According to the, and my lord, kindly see on page 20, according to the railways guideline, without without NOC from railways, the private construction cannot be made.
Procedure for issue of no objection certificate for construction or redevelopment of government or private building adjoining to railway boundary.
My lord, clause 2, my lord,
Yes.
railways NOC is required for construction of building within 30 meters from railway boundary as per so and so instruction with regard to issue of no certificate for consideration of
So
redevelopment.
who will forward your application?
Yes, madam. My lord. BLR will forward the application and railway authority, divisional railway manager will.
Where is your application, sir?
Yes, yes.
It is at page 31.
Page, first madam, page 31 is the, madam, first my lord, page, start from page 36, page 42. This is my lord, representation made addressing the railway concern authority.
Application for forwarding our prayer.
No, my lord, first my lord, forwarding our prayer dated only 19 March 2024. First my lord, I have made application addressing the railway authority or district divisional railway manager. 42, my lord.
Page number 42.
Yes, ma'am.
Page number 42 is the last page.
Last page, yes. Last page of
Where
the,
from it begins, sir. What is your application?
this is application, my lord, addressing the railway authority. Well,
That
kindly
starts
see, ma'am.
at page 36.
A man namas is never to forward the application of the who is the respondent number 5. 5 is the railway authority.
Forwarding application made by
Respondent
lord letter.
BLRO. So where is the application with the BLRO? Show me.
Yes, madam.
But that
Start
is at
from
page 31.
31 and page 35 is the date.
Page number 31.
35 is the 31 is the receiving date and date of representation.
Sir, try to understand. What is your prayer? Kindly read the prayer.
My
Sir,
prayer,
kindly read the prayer first.
a rate in the nature of magnanimous directing the respondent of 5 to forward the application of the petitioners for issuance of NOC of building permission rated at so and so with relevant enclosures. Respondent of 3 as for forwarding application made by the petitioners dated 9th of April 2024.
So, from your prayer,
Yes, ma'am.
kindly listen, sir. From your prayer, it will reveal that you have made an application for the respondent number 2, 5.
Yes.
You want respondent number 5 will forward the same to the respondent number 3.
Yes.
Am I correct, sir?
Yes.
And you further want that the respondent number 3 will
Yes, sir.
consider in
Yes.
accordance with law.
Yes.
So for that you kindly place where is your application which is addressed to the respondent number 5.
Application respondent of 5 starts at page 31.
Yes. What is their application?
Forwarding.
Application for forwarding our prayer made to the reference such and such for issuance of act. Very good.
Yes.
What
Page
is the
35.
subject matter?
Page 35, my lord.
Page number 35.
Yes. Date of representation.
We request your forward your application. So what is the contention in the your application?
Yes, my lord. The contention of this application, my lord, And there,
এই
that's
partial
why, my lord, I am
replacement হয়
addressing.
এত মহা মুশকিল জিজ্ঞেস করছি এক বলে আর এক near
To
the plot
forward the
Sali land for the
application.
purpose of we have purchased the same to mutating our name we applied for the eto for conversion to Bastu. You want to make a building
Yes.
since our lands are situated within 30 until around that. Very good. Then what happened?
Neither the BLR forward.
It has not been forwarded.
Yes.
We don't have.
Forward, sir.
With us, let it be within a time frame, it should be forwarded, my lord, in accordance with law.
In accordance with law.
And who will consider your application then?
The railway authorities.
Railway authorities, the respondent number?
3.
Very good.
Well, kindly indicate the
Last one.
the application made before the respondent number 3
The affidavit of services filed today is taken on record. The repeat
Identical,
along with the
or may I?
request letter.
So, we have to decide in accordance with law.
আচ্ছা ওই জায়গাটা কি বলেছি একটু বলুন তো ওই জায়গাটা বলেছি ওই যেটা বললাম না
No, 19th of March, my lord, separate date. Date of forwarding application is a date of BL before the respondent 5. Respondent number 3. Date of, kindly mention the date.
Respondent number 5 will forward to the respondent number 3.
Yes,
Respondent, what is the date of the representation? Before the respondent number 5?
9th of April,
That will be forwarded.
that will forward it. And my lord, NOC of application for NOC dated 19th March will considered by the respondent number 3.
How?
I have
Filed a what?
made a prayer.
We made 2 applications.
Yes.
One to the
One
state
address.
authority.
Direct application will not be suffice.
No,
But he has also made an application for
Very
opinion
good.
NOC.
Let him
But I
make
have
application.
Both the application to
No, no,
forwarding
no,
by
no,
the
no,
state authority
no, no,
and
no.
that to be
No,
disposed.
BLRO. I have made representation before the BLRO addressing the letter made to the respondent number 3 dated 19th of March.
The BLRO will consider your application dated 9/4/2024
Yes,
in accordance with law,
yes.
and in the event he finds sufficient merit in that representation, he will forward it to the respondent number 3,
Yes.
who then will consider.
And automatically the NOC or
Automatic-
whatever it is will come.
Yes. Yes. You get it?
Separate to me.
এটা এই ভাঁজটা খুলবে না, আমি দেখে নেব। ফাইলটা দিন।
On 11th April, your lordship passed this order. Paragraph 8, my lord, of your lordship's order.
আসুন, on behalf of the respondents,
My lord, I beg to appear for the petitioner.
appearance below.
Here, what has happened, my lord, the mighty state, without any acquisition procedure, has tried to seize possession of my land, of our land. Now, earlier they had done this same mischief in the year 2007, when, my lord, a joint resolution was passed between the villagers and the state. Your lordship would kindly comes to page 51. My lord, it starts at page 49, but I'll be placing page 51. At that point of time, they had ventured into construction of a 12-feet road that is at 4, my lord will find. Upon completion of 12 feet wide paved road, the ownership and possession of the land on both sides shall remain vested with the respective riots. Now, riots means us, the villagers.
What does mean upon completion of 12 feet?
Paved road, the ownership and possession of the land on both sides shall remain vested with the respective riots. So at that point of time, it was agreed that only 12 feet road will be constructed. Now kindly takes paragraph 6. We had expressed our concern, my lord will take. However, based on past experiences, the riots expressed their concern that in future authority might unlawfully acquire their land without compensation by altering Dag and Mouja records and or by reclassifying the private land adjacent to the road as public property or through other means. Thereafter, my lord would kindly take page 52, that is the third paragraph. The state BDO assures the BDO has clarified that without the express consent of the lawful landowners, road construction could not proceed. Therefore, should the riots raise objection, he should take appropriate steps to prevent construction agency from continuing work and ensure their withdrawal from the site. He emphasized that once removed, the agency would not return. Now that this was the resolution that was taken in 2007. Now what they have done, this 12
Resolution.
this is a joint
Resolution by and between?
by and between the state and the villagers. My lord, it starts at page 49 and it is in Bengali. This is translated copy. Your lordship will find the signature of the block development officer Daspur 2. It starts at page 45, the Bengali translation.
Very good. Then what happens?
Now this time what they are doing, this 12-feet road, now they are trying to extend it to 20 feet. Now we had raised a representation that without acquisition, and my lord knows under the Right to Fair Compensation Act, my lord, any land that is to be taken by the state, my lord, we are to be paid acquisition. Now, my lord, they are venturing upon seizing the possession of our land without proper acquisition procedure. Now, my lord knows law respects possession, and being the mighty state, my lord, it is even in a higher pedestal that it should maintain its duty of acquiring first, and then, my lord, will proceed with the construction of the road. My lord, it is in excess of their duties, my lord, they are crying with to seize possession. Now, we had raised a representation, my lord, earlier occasion in another in the same block, my lord will find a similar order at page 76. My lord, this is in the same block, I am told, my lord, an order has been passed whereby the state has been said that if in any event they try to seize a private land, my lord, they ought to take appropriate proceedings under the acquisition, law of acquisition. My lord, let them see, my lord, of course a road is for public purpose, but at the same time, Rayati land cannot be taken by muscle power, it has to be done in accordance to law. Let them give us our compensation.
Yes, Mr. Dhar.
Number one, West Bengal State Rural Development Agency not made a party. They are the nodal agency for execution of this project or scheme. Number two, the road has been already constructed, already done. So now, number three, there are so many writ petitioners. I don't know whether 37, how many have paid the court fees.
Yes.
And fourth would be, my lord, this is a factual thing, my lord. What was the, my lord, amount of encroachment or width or the length, my lord, that has to be done. Inquiry has to be made in presence of the BLLRO as well as in presence of the Panchayat Authority and BDO. Now, my lord, next point would be, my lord, whether Panchayat Authority has been served.
Yes, yes.
Because they are the
Who is the nodal agency, Mr. Dhar?
West Bengal State Rural Development Agency.
Yes.
But the affidavit of service confirms service, my lord.
But not to upon West Bengal State Rural Development Agency.
Has not been made.
What is the supplementary affidavit for?
My lord, supplementary affidavit, my lord will find, my lord, we have annexed the Mouja map, my lord, wherefrom it would be evident that there is no road in existence. In the Mouja map, there is no road in existence, and they are trying to construct the road.
My lord,
Now, my lord, only one thing, my lord,
my lord,
my lord, only one thing.
my lord, let my learned friend submit.
My lord,
I'll
admittedly,
give the
12 feet road has been constructed in the year 2007. Now what they are venturing upon, my lord, the photograph of the signboard will reveal that now they have taken that it as page 53. They have taken this recent undertaking to construct, to extend this road to 20 feet. Kindly takes page 53, my lord. রাস্তার নাম রানীচক পশ্চিমপাড়া হইতে পার্ট 1 প্রকল্পে 5 বছর, my lord, will finally date at 19/3/2025. So it is a statement being made by the state that road has already been constructed. No, yes, road has been constructed in 2007, that is to the extent of 12 feet. Now they are venturing upon further extension. We are on the further extension, my lord. My lord, let them file a report, and when till such time the report is being filed, let them not seize possession, my lord. That's our limited prayer.
Construction is already done.
No, Mr. Dhar, in the event the jurisdictional BLRO make a field inquiry, securing the presence of the writ petitioners and the relevant the Panchayat Pradhan, and in the event it finds, and he will submit the report with the BDO, and in the event if the BDO finds that there is sufficient merit in their representation, he will proceed in accordance with law.
Yes,
And in the
absolutely.
event they will, if he finds no merit in at the time of after obtaining he will permit the respondent number 10 to carry out the work. But
It's been carried out.
No,
it's been my instruction is it's been already done. So
widening has been widening.
Yes.
Then he will forward the report to the district land acquisition officer for initiating appropriate proceeding under the 2013 Act. Very good. Take down.
My lord,
Now,
they have
if-
given this, they have submit, they have
Very
given
good.
this.
Listen to my order. The affidavit.
Getting improved metal road. So PMJSY scheme is road is already there, more than 40 years, more than 30 years.
In the event a report is received after inquiry that yes, some
There is an encroachment.
then who will initiate the process
The process
of
would be,
acquisition?
yes, Panchayat authority, from the Panchayat authority to BDO, BDO to PNRD department, then PNRD department would write the district magistrate of that district that.
District magistrate is the party.
Yes, yes.
Yes, my lord. On
Well,
16th,
let
my lord,
that-
an inquiry is to be held, my lord. My lord, this has been given, my lord. Kindly take. On 16th, my lord, I'm
কি আছে দেখি?
this is given by the concerned Black Land and Land Reforms Office. My lord, on 16th, my lord, an inquiry is supposed to be held, and my lord, on 19th, the work has commenced. My lord, they have simply given an body holding, and the work has completed, my lord.
I must not stand in the way of development of a road. In the event they will find, they will initiate a acquisition proceeding.
Your
under
lordship,
30 of
your
the-
lordship would kindly then record, my lord, that the interim order is refused, my lord. Otherwise, my lord would kindly consider.
Interim order as prayed for is refused at this stage. The interim order as prayed দেখি কি আছে তা ওটা দাও।
Application for renewal application and the impugned order and the first round
Same,
requisition.
remains as same.
All the same. Even all the same. The necessary correction I have already changed. This is also the second round of petition. The first round read petitions number is the order is 104.
সৌরভ এটা তোমারই আছে।
অলরেডি চলে গেছে।
Good.
What's the matter? Next. Who's for the petition?
I am appealing for the petitioner, led by Mr. Shubhangshu Panda. Lordship, here's similar order.
What target method is
The exactly identical matter, the other family member was approved before this court and passed an order, the praying for the consideration of the representation. Initially, the authority was the only have corrected the date and cost title. Otherwise, page number and other is everything is same, and WPA number. My learned friend was also appear. Representation. That was my allegation. Which is 69. We have raised a criminal case.
Representation consider করে দিই
ওটাই বলেছি। My lord, only one thing, my lord, this page 77, my lord, it is not a representation, it is a letter of the advocate.
Based on order passed by the Honorable Court, my lord. Kindly
Yes,
the
my
order.
lord, only
Order 69, my lord, the criminal case was
77, my lord. My lord, he is now, my learned friend's contention is to dispose of his representation, my lord.
That is
Only my point is, my lord, this page 77 is the notice of the learned advocate.
no, my lord. Kindly see the representation, my lord. Before that, my lord, kindly consider my lord case.
My lord, my only contention, it is not a representation, my lord.
Comprehensive.
No, my lord. I think, my lord, both the learned friend as my lord has not gone through the brief. My lord, page 69, kindly consider.
This is the order.
Yes,
Page
my lord,
69
this order.
is the order.
Kindly see the order. Order is
You
the, what
asked
is
me
the
for
order?
the disposal of the representation.
My lord, kindly
Where
see
is the representation?
My lord, kindly see the representation page, order on page 73. The disposal of the instant criminal revision shall not be debarred the private respondents to raise their claim for fair compensation. My lord, I made a representation on behalf of my client.
That cannot be.
Why not?
I am objecting to that, my lord. That is not possible.
My lord,
Let
the
him
court
make a
has
comprehensive
my lord directed. I have made a representation.
No, it's an advocate's letter. Advocate letter should not be a My lord, your lordship, if your lordship ordered, then we shall consider it. We are bound to
My lord,
obey your
that is
lordship.
our contention, my lord. It is not my learned friend said
And the
this is
same
our
order, and the same,
Bound to obey your lordship's order, my lord.
This is our
But it is
and
not
the same
that
order
my
was
lord
passed.
has made
My lord, now, my lord, 2022, my lord,
What
made an
my-
application. You have not
my
taken into
learned friend
consideration.
totally different point. Argument is going on a different issue.
This is, my lord, the delay tactics of this.
কি বলবে বলুন, কি বলছে আর উনি কি বলছে?
রিপ্রেজেন্টেশন প্রসেস
হ্যাঁ
7 দিন বা 10 দিনের মধ্যে রিপ্রেজেন্টেশন দাও, মাই লর্ড অর্ডার দিয়ে দেবেন।
আমি বলছি এইটা, মাই লর্ড।
Of the order.
Yes, yes, my lord. On the last occasion also, my lord, his advocate letter is called his representations on. My lord, I am not on that, my lord. He totally harping on the point that to consider my representation. My lord, only I am on that. Yes, my lord. Yes, my lord. But my lord, he said that he's the representation and only on that.
Hello, sir. I don't know. You are disposed of. No. Affidavit.
Lord, this is my application. Is there a private respondent here?
Yes, my lord. Private owner, he is one of the co-sharer of the property, my lord. My lord,
Service has been affected upon the private respondent.
yes.
What is the service? Hamoli Halda.
He is our sister, my lord.
Item dispatched. No, service is not complete.
My lord, she is my sister, my lord.
What is your prayer?
My prayer is that, my lord, if your lord kindly takes up page 42 first.
Give me a second.
My lord, time and again I made representation to the authority.
Just a minute, sir. Yes, page number
My lord, page 42 kindly sees, my lord.
40?
42.
Yes.
My lord, this is the RTI report given by the my lord, land acquisition officer, saying that my lord, this property is not under any LA case. That means, my lord, this property has not been acquired by the government.
Yes.
But, my lord, if your lord kindly takes up the photograph at page, my lord, 46, my lord, kindly please, my lord.
Page number?
Page 46.
Yes.
My lord, there your lordship will find, my lord, this plot, my lord, I am the owner of 45 decimal of land, my lord. There, my lord, the building was constructed the PWD. My lord, kindly come to page 47, my lord. Your lordship will find, my lord, the second photograph, my lord, at the bottom, kindly sees, my lord, Government of West Bengal, Office of the Assistant Engineer, Kolta, PWD roads, my lord, last line, my lord.
Hmm.
My lord, this property was in my property, my lord. They have constructed this PWD, my lord, the engineering building there. And my lord, they also constructed, give a boundary wall. And my lord, the sketch map I have, my lord, prepared, if your lord secondly takes up at page 51.
Page number?
Page 51, my lord.
What is that?
Page 51, 51, my lord.
Yes.
My lord, kindly see, my lord. The plot of land is there, my lord. 45 decimal, my lord. Late Okul Chandra Haldar, my father.
Page number 51.
51, my lord.
Site plan of Sali showing plot area plan of late Okul Chandra Haldar.
My lord, plot number A, kindly sees, my lord. Plot number A, kindly see there is the boundary wall. Including that, inside that plot, my lord, one pond is also there. And PWD, my lord, raised this boundary wall and they constructed their office.
At which place?
At the place at that dark number, my lord. Dark number 608.
608.
My lord. And my lord, time and again I made representation to the authority concerned, my lord, PWD, my lord. The last.
What is your representation?
My lord, kindly come to page 50. 52,
Page?
52, my lord.
It's a land acquisition officer.
lord, the relevant pages at page 53, my lord.
So, Mr. Bandyopadhyay, let the jurisdictional PLO make an inquiry, field inquiry, after securing the presence of the writ petitioner, and he shall submit a report to the respondent number 6. And in the
My lord, report may be submitted to your lordship, my lord. Let them submit a report.
no.
Otherwise, my lord, they
To
are
whom it will be submitted? To the
well, the
respondent number 5 or 6?
PWD will submit a report, my lord.
Huh?
Since LA has been LA official.
না মাইলর তো তোমার ফেভারই বলছে শোনো না মাইলর কি বলছে আমি মাইলর কি বলছে শোনো না মাইলর your lordship direct the PLO concern to make a survey and file a report before the PWD authority as because my lord their allegation against the PWD roads have been constructed without any acquisition process.
PW road is not a party, that is the difficulty.
Yes, my lord. Can you see the
Huh?
2 and 3.
2 and 3 are the PWD
and
roads,
three.
my lord? 2 and 3, my lord.
2 and 3. Your lordship direct the
And in the event it is found that
then appropriate step will be taken
by the PWD authority
PWD authority.
or the land acquisition officer.
No, my lord.
My lord, land acquisition officer already submitted a report saying that this property is not on the subject matter of any LA case. My lord,
No,
PWD
what I'm on, sir.
But
In the
first
event
let the DLRO make an
inquiry, he will
and file
submit a report with
before
whom?
the PWD authority.
Ah.
If it is found his land has been utilized by the PWD, then appropriate step will be taken for making payment.
By whom?
By the PWD authority. As because my
PWD
lord,
authority is a requiring body, no?
they are the requiring body, my lord. When my lord the acquisition process is started, in this case, my lord, already it is his allegation already without acquisition process, his land has been utilized. When it is
But in
utilized,
the event it is utilized, the land acquisition proceeding will be initiated by the respondent number 6.
but no, my lord. They will send a proposal before the authority for acquisition or making payment compensation.
my lord,
The respondent number 6 has got no role.
No, my lord.
Kindly see.
Yeah, I have seen, my lord, land acquisition collector. As because this land is not involved in any case, my lord, page 42. Therefore, my lord,
unless, my lord, the thing is that if I submit, my lord, PWD wants any property required for them, my lord, they will send a proposal to the LA, my lord. Then LA will notify it official gazette, my lord. Kindly see section. My lord, kindly see section.
therefore, there is no question, my lord, further
My lord,
acquisition.
PWD can be
They will
the
make
judge of his own
payment
cause,
by
my lord.
purchase
What
or
my land is saying, my lord.
He is supporting Mr. Bandyopadhyay is
My lord,
supporting.
he's supporting, but my lord, the question is that PWD cannot be a judge of his own cause. My lord, now he wrongly, my lord, without.
What do you want now?
I want, my lord, let this report to be submitted to before lordship, my lord. Let petition pending, my lord. Let report be come to your lordship, my lord.
No,
PWD
no.
also come. My lord, PWD
As soon
will
as
be today, my lord.
the affidavit of service,
Then purpose of the writ
the
petition will.
affidavit of service as filed today is taken on record. By filing the instant writ petition, the writ petitioner has paid for issuance of
I am the petitioner.
Where is your affidavit of service, sir?
Yes.
Is there any private respondent?
No. The land of the petitioner was requisition on and under Act 2 of 1948. Thereafter, no acquisition, and in the meantime, scheme has been abandoned. And I am entitled to get back my land and compensation relating to requisition and damages. And this is covered by your lordship's order, my lord. Your lordship, last week your lordship passed an identical issue, my lord. And may I place, my lord?
দেখি দাও
Under the same scheme. Only the date of representation and covering page will be changed.
We have got 5 lead petitioner in the same manner. Let them make payment of portion.
For the legal layers, my lord, the joint owners.
সবাই নয় সবাই নয় সবাই নয় দেখি
Is their joint owners.
দিনে আলাদা বাবা বাবার নাম আলাদা
Maulovi Mollik is the original owner. Thereafter, his one son died. Thereafter, we are the legal present owners.
Who is the respondent for?
Yes, special LA, special land acquisition officer.
Your representation dated?
15th of January 2024. Page 31 to 34.
15-1.
And may I hand over the corrected copy? I have corrected one copy.
Oh, give it to me. Mr. Bandyopadhyay, let them consider in account. এটা করে দেবে এখানে যেমন যেমন আছে মিস্টার সৌমিত্র কারেকশন করে দেবে এটা পাঠাবে কিন্তু আমরা এইটা উকিল বাবুকে ফেরত দিয়ে দিন নেক্সট
Lord, I don't know particular time for the point.
My lord, learned advocate Mr. Owen Banerjee appearing for the state, my lord.
Sorry?
Learned advocate Mr. Owen Banerjee appearing for the state, my lord. Last occasion, your lordship direct to the state authorities to file a report in form of affidavit, my lord. But due to some instruction, the report could not prepare in the meantime, my lord. I am praying for only not today.
On behalf of the respondent state. Yes, and on behalf of the respondent state, an accommodation has been
Lord, I purchased the property from unutilized area and the leftover area by the valid deed, and my name was recorded in the LR record of right.
Unutilized area and unacquired land, unacquired area.
Unacquired area, that is the leftover area, 12.38 decimal.
Now you pray for refund of the unutilized area.
Not the refund, Lord. Release order.
Return.
Those were Lord, I purchased the property. My name was recorded in the LR record.
If it is vested with the state, how can we purchase?
Lord, subsequently they recorded. They did not record by that land in the Lord Khotian 1.
That does not that creates any title. How create title is created in your paper.
Lord, subsequently
Recording of name creates any title.
No, but title deed is there, Lord. The Rai's name was there, Lord.
Sir, the land was vested with the state. You purchased a portion of the vested land. How you became the owner, I cannot understand. What is your contention?
Lord, because Lord, in the writ petition, another point was taken.
What is the policy for returning of the acquired area? That I fail to understand.
Lord, there is a writ petition. Kindly see the page. Lord, the page 29. Lord, kindly first see the page 29, then 32.
What is your prayer? Fail to understand. Directing the respondent to issue release order in favor of the present bidder with the certificate and land measuring eto. Land measuring is totally. Madam, how can it be done? I cannot understand.
My lord, in this matter, my lord, the subject land and Mouza, Gauripur and Doharia, my lord, district North Chobbish Pargana does not come under the administrative control of NHAI, my lord. My lord, it is under the control of NHPWD, respondent number 9, my lord. The state is the answering respondent. Lordship, in this matter, my lord, I have no role. I have not acquired any land under the NHI, my lord. Only the NHPWD is the administrative control. The land has been taken, my lord. It is not maintained by NHI, my lord.
State accommodation has been paid for. It আসুনে হবে না.
My lord, in this matter, my lord, my name can be expunged, my lord, because in this matter, my lord.
No, for the time. On behalf.
The case in short, Lordship, is that one of the petitioner before your Lordship, the trust, the religious trust. I mean, initially,
Sir, give me a second. Hey, read petition কোথায় গো? The status report. Give me a second, sir. Has it been heard by me on an earlier occasion? No. For the first time.
My Lord Justice Rai on earlier occasion.
where my lord hearing was held.
Give me a second.
That lordship will find in the earlier.
Yes, make your
My lord,
submission.
the petitioner before your lordship is a religious trust. Now, my lord, initially in 1994, my lord, vesting order was passed, my lord, under the West Bengal Land Reforms Act. Now, my lord,
Vesting order in respect of which land?
of this is, my lord, in respect of a land situated in Lilua, Howrah. I will take your lordship to that. My lord, we came before this High Court. The High Court granted an order of stay. My lord, while this order of stay was operating, my lord, again another notice was given. Lordship will find that at, my lord, page 33. Lordship will find it. Page 33.
Give me a second.
Annexure P2.
What's your good name?
Shubhankar Nag.
Shubhankar?
Nag.
Page number, sir?
Page number 33. P2, my lord. Again a notice was issued. May I place the notice and then, my lord, place before your lordship. Now, my lordship will find, my lord, the day.
Page number 33.
33. Is
Yes.
a notice in Bengali. Lordship will find the date of the notice is 30th October 2000. It is very important. Why, my lord, I tell you, lordship. To the petitioner, এত দ্বারা জানানো যাচ্ছে যে পশ্চিমবঙ্গ ভূমি সংস্কার আইন 14T ধারা বলে মোতাবেক তপশিলভুক্ত জমি সরকারের বর্তায় কেস মতামত আপনাদের নিয়ম মাফিক উক্ত দখল গ্রহণ করেন উপযুক্ত আইন অনুসারে কোনো স্থগিতাদেশ নেই এমত অবস্থায় নিম্ন স্বাক্ষরকারীর উক্ত সম্পত্তি সরকারি আইন অনুযায়ী ব্যবস্থা গ্রহণ করবেন এই বিষয়ে যদি কোনো আপত্তি লাগে আগামী এই তারিখের মধ্যে প্রয়োজনীয় কাগজপত্র নিয়ে এসে দেখান নাও মাই ল্যান্ড কনসার্ন ইজ অ্যাট পেজ 36
এই একবার দেখি একটু এক সেকেন্ড ইয়ে করলেন ল্যান্ড রিফর্মস একটা বার করে তো বাবা একটু বার করুন এখানে আছে
According to the provision, my lord, this petition is not maintainable here. In spite of that, my learned friend wants to.
No, I will also show judgment of division with saying that is maintainable. This type of writ petition is maintainable.
এটা এখানে আছে কোথায় না
No, my lord, lordship does not have to go there right now. My lord, I tell you, lordship. My lord, what happened, my lord, in 1996?
ইতর দ্বারা জানাতে পশ্চিমবঙ্গ ভূমি সংস্কার আইন এর 14T ধারা বলে 1/94 কেস নাম্বার সরকারের পর্তায় 14T is
14
West Bengal Land Reforms
duty of the riot to finish
Huh?
done.
West Bengal Land Reforms Act, my lord, 1955.
that exactly I'm on that 14T is the duty of the riot to furnish return.
Well, I tell your lordship why it is not necessary. My lord, kindly grant me 2 minutes. Well, in the year 1996.
Just a minute, sir.
Subsection 6 is necessary in respect of my case. Lordship will find the revenue officer on his own motion or upon any information may, after giving the person interested opportunity of being heard, inquire and decide as to whether any trust, endowment or institution is of public or private nature, of exclusively religious and charitable is character or both, and any question title identical thereto as may necessary to determine the extent of land is to vest in state under 4A. So I am a trust. So under this provision, 14.6, well, the notice was given to me, 14T6. And thereafter, any person aggrieved by any order may prefer appeal. My lord, we have done so. And thereafter, we have also went up, my lord. I will tell your lordship that. But my lord, the preliminary question,
So by issuing this notice, the reviewing officer proposed to proceed under section 14T within clause 6 and given him an opportunity of hearing as to why he shall not proceed for taking appropriate steps of the vesting of the land
correct,
in excess of the ceiling area.
ceiling land.
Very
Now,
good.
my lord,
Then
my question, my lord, I tell your lordship, now pausing here for a moment.
Hmm.
In lordship sees the notice date is 2000. Now, when actually in 1996, this division bench, my lord, in his judgment of Mujibi, my lord, declared this provision ultra virus. Because this
14T
base
is not ultra virus.
I will tell, I place
14T is not my ultra
I will
virus.
I will show that from the judgment. I will show from the judgment. I am not saying, I will show from the judgment.
14T is not.
I will show, I will show. So declared ultra virus. So after declaring the ultra virus, many as party went up to Supreme Court. Now, the Supreme Court said, Supreme Court granted an order of stay in respect of such order. Status quo.
No, my lord. Status quo has two positions.
बोलते दिन आपने तो
No stay, my lord. ये बोलो Supreme Court order.
My lord, order was passed. Now, my lord, the question is, then came up before the division bench of other court. If there is an order of status quo, then, my lord, what happens to that? Well, the division bench of this High Court also clarified the fact, saying that, see, even if an order of status quo has been passed in respect of intra-party, but the operation of judgment is not nullified. So you cannot exercise any power under that. It is also passed by the division bench. So that is the law. So in the year 2000, my first question is, the state could not have issued the same notice. Now, my lord, after this notice was issued, my lord, we again came up to High Court. And my lord, a status quo order was passed. And thereafter, my lord, ultimately, under leave granted by this High Court, we went to WBLRTT. And there also, my lord, there is a status quo order passed. My lord, lordship will find that at page 51, the date as your lordship got that, my lord, 12th May 2023, my lord, lordship will come to, my lord, page 52, second paragraph. Consider the submission of both sides with regard to pair of ad interim injunction only. Peruse the case records on analyzing and synthesizing the submission as to be expected forcible threat of disposition, consequent injury thereto. We find that the applicant has a bona fide contention. In view of the urgency of the situation and as an exceptional measure, as well as applicants needs a cool whiff of preventive order to preserve the nature, character, possession of the property as particularized in the proceeding. Otherwise, if the appellant made to wait till disposal of injunction petition, which will be hard after the filing affidavit, the appellant may have to face disastrous consequence in under imminent threat of disposition. In such event, delay may defect object purpose of injunction make the proceeding infructuous. So absolutely for a limited period, we direct the rule of injunction be issued asking at once asking the parties to maintain complete status quo as it stands today in respect of the property. The issue before your lordship is now, in spite of such order is still operating, extended. Now, my lordship will come to page 11, page 63, annexure P11. But what happens now? They put up lordship will, page 63. Lordship sees, my lord. Now they are trying to interfere with the possession. My lord erected board on the wall. Lordship sees the next. My lord, this is a property belongs.
File a contempt before the tribunal.
No, my lord, before the tribunal is not the thing. My lord, lordship sees now it is, my lord, not only in this case but in respect of other cases also. They have been doing so in respect of the same trust. My lord, I can show that. My lord, even in, my lord, lordship will find at page 56. My lord, they have taken the same thing and the order was passed by this court. Lordship will see page 55. So again, my lord, this is continuing against me. Now, my lord, the question is today, my lord, if the order is itself, now, my lord, kindly have a look at the, my lord, the Bhumijivi, the main judgment.
What is your prayer then?
Prayer, my lord, today I am before with a limited prayer, my lord. My prayer is not to dispossess me and remove this signboard. My lord, by filing the status report, the contention of the state is
no, remove all encroachment and signboards.
Signboard. My lord, but my lord, they have filed a status report in terms of this.
Why are not when the LRTT is in the scene of the matter? Why are not approaching there?
Well, LRTT does not have the power to contempt. Well, power to contempt is not there with the tribunal.
No, LRTT has passed an order of injunction.
Correct.
LRTT has passed an order of injunction.
LRTT has the power.
So, and in the even the injunction order has been passed and it has been violated. So why not approaching the tribunal?
That is still pending.
Well, I tell you, lordship, the main issue before your lordship is that even the notice itself is illegal and without jurisdiction.
What notice has been issued?
This 14.2, the notice I have showed before your lordship.
That is the subject matter of the tribunal.
Well, a subject matter of the tribunal, correct. But the issue today is, well, they are, well,
tribunal, when the tribunal is sitting over the matter.
Well, kindly have a look at the unreported division bench order. Well, in similar case, well, this division bench of this court passed order. Well, kindly have a look at this judgment. It's not that. Well, kindly have a look at to hand over. No, I have a copy. Well, lordship will find.
Wait, sir.
জুনিয়ররা থাকলে একটু অ্যাপ্রিসিয়েট করুন, অ্যাপ্রিসিয়েট করছে, এটা একটু বেশ দারুণ করেছে। বাবা তোমার ঠিকঠাক আমি এতদিন
স্যার আপনার সঙ্গে অন্যরকম সম্পর্ক।
Sir, you have
Well,
remedy under section 13 and 14 of the tribunal.
kindly have a look at the division bench order in these cases. Malad, because Malad, it's a point of law involved. Also in the last order, also it records, well, it's a point of law involved that whether a notice can be issued even after passing this. And also,
Sir,
Malad, kindly have a look.
Rightly or wrongly, I will shall see. Rightly or wrongly, a notice was issued under section 14T. Am I correct?
Lordship.
The matter, the correctness of the said notice has been challenged in the tribunal.
Lordship.
The tribunal, while was seen over the matter, has passed an order of injunction.
Lordship.
According to you, during the subsistence of the order of injunction, the respondent authorities, in utter violation of the order of injunction, has put up some signboard.
Lordship.
So, where is the predicament of the writ petitioner? Proceed the tribunal under section 13 and 14.
Malad,
That I intend to know.
Malad, I am telling you, Lordship. Malad, also, Malad, in the writ petition has.
Sir, when there is a statutory alternative remedies available,
Malad,
then why are you approaching the High Court?
Malad, I tell you, Lordship, why, Malad? The question here is, Malad, also, Malad, a point of law is involved.
Execution of order passed by tribunal, an interim order in and an order finally dispose of any matter or proceeding by the tribunal, including an order as to cost, may be executed in such manner as may be prescribed. 14. Proceedings to be deemed to be judicial proceeding. All proceeding before the tribunal shall be deemed to be judicial proceeding within the meaning of section 193, 219 and 220 or 8 of the Indian Penal Code. Section 15. Power to punish for contempt of tribunal. The tribunal shall have and shall exercise the same jurisdiction, power and authority in respect of the contempt of the tribunal as a high court has and may exercise for the purpose the provisions of the Contempt of Court Act shall have effect subject to the modification that the reference therein to a high court shall be construed as a reference to the tribunal and the reference therein to the Advocate General to section 15 of the said act shall be construed as a reference to the Advocate General of the state. Then
because Malad, of this division mean judgment we came. Malad, kindly have a look at the
division mean judgment.
That I have given also a copy to my other side. Malad, Lordship, see. Lordship takes second page, last paragraph onwards. Second page, we have informed most of the orders passed by the court restrain the state and its officer from taking possession of the lands in dispute. Though liberty was granted to the relevant officer to complete the proceeding to pass final order, even to such and such pending decision in one such order of the coordinate bench was carried out Supreme Court. This order is final order. Supreme Court has been the other order. Supreme Court relied on by such and such and interim orders whereby notices have been issued by operation of final orders passed by have been stayed. However, there is no dispute against the last order by another coordinate bench which has been placed before us. No appeal has been pending before Supreme Court. Mr. Shahul, an advocate appearing for the petitioner, has draws our attention to several orders passed by the Supreme Court as well as coordinate bench. The essence of the order is still such time Supreme Court disposes civil appeal. Proceeding of vesting initiated relevant may be disposed, may continue, but final order of vesting may be passed, but the riot may not be disposed. There is further direction while continuing possession shall be restrained from creating third party. Such and such appearing for the respondents have not been any taken view contrary. That in view of the matter, we admit the writ petition direct a stay of operation of honor challenge shall remain restrained, interfering with such and such, since the pending They no sin that now there is apparently no reason to take a different view from the second. We have been informed. It is important. At 12 noon today, possession of the disputed land was taken over by possession, and a board has been installed, thereby conveying to the public as large possession is respected no longer remains with the petitioner. Immediately, under such and such, the respondent shall remain restrained from interfering with the possession of the land. Relevant block and notice by the tribunal, correction of the right will be made. This is the way. So that is why we come. And also,
my lord, please see the number WPLRT.
well, and
That
also
is against the order of the authority of division
also
bench.
they also
Not my contention that petition is not maintainable as because my lord, this is a single bench.
And
if he wants to say something, you must come with the division bench. in WPLRT.
well,
এই বইগুলো বার করুন তো ভাই, এই দুটো বই আমায় দিন।
well, at one liberty may I ask from your lordship?
No liberty, sir. I have heard you.
No, well, one liberty, well, because if I go back to WBLRTT, well, I will not get a date before 1 year. That is the practical predicament every litigant face. Well, kindly pass a direct, time bound order to dispose of the LRTT to the application filed in this regard before the LRTT. That what
You have not filed any application as yet.
But I will file with
in anticipation, everything will go.
Well, kindly seize that is the normal predicament. This is a division bench order where there is an order was passed and then that is why we are before your lordship. All I am seeking is a liberty, that if I file this application, the LRTT will consider within 2 weeks. And in respect of the point raised by my learned friend in Bhumijibi, 14T has been stayed. I will show that portion.
No.
I will show that.
No.
I will show that portion. I will show that portion.
সুপ্রিম কোর্ট অর্ডারটা দাও না,
আমি দেখাচ্ছি তো,
হ্যাঁ দেখাও।
দেখাচ্ছি।
স্ট্যাটাস কো as to possession, that is the
Kindly come to paragraph 107 of Bhumijibi.
whatever may be that, এই কোর্টে তো হবে না, তুমি ভূমিজীবী বলো আর রামজীবী বলো, এই কোর্টে তো জুরিসডিকশন নেই।
Single bench has no power.
পাওয়ার জুরিসডিকশন
It should be applicable.
জুরিসডিকশন থাকলে আমরা কেন বলবো?
আমার সঙ্গে কেন মামলা করছি না?
তোমার সঙ্গে কি তো মামলা? পড়াশোনা করছে তোমার সাইড করে।
Kindly have what is stupid. Just one paragraph for my satisfaction. Lordship, this Supreme Court, this division bench judgment.
By filing the instant
of within 1 month, my lord. My lord, only one liberty, my lord.
First approach
My lord,
then, my
my lord, kindly, my lord, because lordship knows I don't get a date. even
Sir,
within
if
1 year.
if you do not approach, why should the court power? That too, you have to file before a division bench.
Liberty, my lord, lordship says, my lord, liberty to approach and to finish, my lord, within
Sir,
1
why
month.
liberty? Statute gives the liberty. Why should I give the
My lord,
liberty?
I am just seeking for giving me a time frame, my lord. Kindly consider this one, my lord. Or, my lord, I will not even get a date before 1 year.
টাইম না তো
চারটে তাহলে মেনশন করে
আমাদেরও মেনশন
চারটে চারটে
Item number 68, my lord. I seek my lord's kindly, my lord, if your lordship takes it up any day, my lord, subject to convenience, and if your lordship kindly takes it up to 2 p.m. or yes, any day, my lord, after yes, any day.
After the
My lord, if your lordship takes it up, my lord, on 11, 12. Yes. So, my lord, any day, my lord, on 11, 12, or my lord, or not in this side of it. It's 68, my lord. I am for the petitioner. My learned senior friend is for the, my lord, for the, my lord, state respondent.
চেম্বার জুনিয়র কে সিনিয়র ফ্রেন্ড
বলা যায় না এটা কখনো কেউ করতে পারে 68 my lord, I appear for the state respondents in this matter. Lordship, may kindly recall, my lord, I had mentioned this matter because I am suffering this interim order, my lord. They are enjoying that interim order. So, your lordship kindly takes it up at 2 p.m. on any day, even after the vacation.
Yes. On
Kindly
12 June,
mark it as at 2 p.m. my lord, any day after the even after the vacation, my lord. Just
11 June, 12 June.
তিন নম্বরটা এম্বারাসিং সিচুয়েশন
কি করে
Yes, call item number 37. এইটা আবার 71টা ওইখানে চলে গেল কি করে? হ্যাঁ, 2 p.m. তো লিখে রাখেননি। ওই ভদ্র আছেন আইটি নাম্বার 71 এর লয়ার আছেন? Yes. দাও। Mr. Pan, you have concluded, I believe.
Yes, no, my lord, only thing is this, my lord, that as I submitted before your lordship, that the state cases, the way the report which has been filed, it appears from the report. Their only case is this, my lord, that so far the delay and laches is concerned, they have not taken this point, only considered they have taken the point that the ratio I am entitled to have the compensation, but on the basis of the ratio decided in the Niladi Chatterjee case. Page 5 of the report, my lordship, kindly have a look once again, kindly at the cost of repetition.
Give me a second.
Page 5 of the report, your lordship will find that the last paragraph, that I am entitled to have the compensation, but not under the provisions of the Right to Fair Compensation and Transparency Act in Land Acquisition, but so in any event, my lord, that my entitlement to the compensation has been admitted by the state. Now, fact remains that on what basis?
Niladi Chatterjee case you have referred, no?
I am not referred. The state has referred.
No, it has been there. It is there.
Yes.
In this compilation.
In this compilation, my lord, possibly my learned friend will rely on this. And that is the judgment I have cited to your lordship, my lord, the Niladi Chatterjee, that the book is there.
Oh, book is there.
Yes.
That I am searching, exactly.
Yeah. This is the book. দেখাবি তো জোসেফকে এটা কম দে কপি দে
অদ্ভুত নিজে টাকা পাবেন আপনি
কপি দে
কি স্টেট জানেন না হত দরিদ্র
স্টেটের কাছে তো এত টাকা এটা এই যে দর্শককে করে this is the photocopy of the judgment
handed over by me.
Yes.
Though Mr. Pan has snatched from me.
বিদ্যাদেবী রিপোর্টিংটা বিদ্যাদেবী আজি জানবি
But you have referred another court division bench of the
yes
in the Ganesh Samanto.
Yes, that state
Yeah, it has been directed to initiate proceeding under section 230. That have gone through.
Now, my lord, the only thing is this, my lord, this matter went up to
And in so far as Vidya Devi is concerned,
that deals
the
with the
Supreme
leases.
Court has practically surprised regarding appointment of an advocate commissioner or something.
That is Azijan Bibi. That is Aziman Bibi.
Oh, that is Ajijan Bibi.
That is Aziman Bibi.
Then in Vidya Devi, what has been held?
Vidya Devi held, my lord, because the delay and latches. The state cannot take the shelter of the delay and latches.
An
It's a
adverse
statutory obligation.
position. Yes, yes, yes.
Yes. No, so my lord, the judgment which has been state is relying upon. If your lordship kindly the copy I have handed up to your lordship, আমাকে দিন তো জোসেফকে দেওয়ার আগে আমাকে একবার দিন আমি শুধু একটা প্যারাগ্রাফ পাস করব এটা তোকে ব্রেকটা মারি জানি আগে তারপরে
Which one is the earlier judgment? Ganesh Samanto is the earlier judgment or the?
No, Ganesh Samanto, I understand the later judgment. This was decided on 21st January 2014, and this was decided on the 2014 was the earlier judgment. This was decided on 23rd August 2017.
No, so far Niladi Chatterjee judgment is concerned, the Honorable Division Bench of this court expressed the view that since the earlier land acquisition proceeding was not initiated under the provisions of Act 1 of 1894, therefore, it by no stretch of imagination it can be said that the provisions of the the Act 30 of 2030 will apply. That is, I believe, the case.
And considering the section 24, that's more surprisingly,
Very good.
Because nobody's case was that section 24 will be applied.
Very good.
It Joseph ke din na. Now the ratio, what has been decided in this, logically, excuse me that I have marked that portion in the facts and circumstances case. So whatever has been decided is the ratio, if at all this is sustainable in the eye of law or this is not par incurium. In the facts of the instant case. So whatever has been decided herein on the basis of the given facts and circumstances of the case. In a particular case that was decided.
I shall consider.
Yes. Therefore, my lord, only thing is this, my lord, and the Adhijan Viva I have handed up to your lordship, my lord, that the relevant paragraphs I have also shown to your lordship. Your lordship must have gone through it.
Yes, Mr. Dhar.
Yes. My lord, may I submit one thing before your lordship?
What more? He has submitted everything.
No. Subject to your lordship's kind approval. I have prepared a list of dates and a short note.
Not required.
My lord.
Usually I do not take any.
My lord.
Usually I do not take. I have taken extensive note of your submission.
I grateful to your lordship. I grateful to your lordship.
If I require, I will call.
My lord.
This third. Yes, Mr. Dhar.
My lord has seen the judgment of Justice Vishwanath Samadar. There few points been decided whether proceedings initiated under Act 1 or Act 2. If it is under Act 2, then it cannot be converted to Act 13. Means interplay of Section 24 of Act 13 and Act 2. As also, that particular judgment has decided that when the writ petitioner has come before the court,
No, so
as soon as
Mr. Dhar, I'm sorry for the interruption. So far as the Niladri Chatterjee's case is concerned, the division bench of this court clearly of the view, since the proceeding was not initiated under the Act 1 of 1994, the beneficial provision of the Section 24, I believe, no?
Section 24
of 2013 will have no application.
will not have any
But
application.
one question has been raised by Mr. Pan that Act 30 of 2013 is absolutely silent with regard to those acquisition and acquisition proceeding as has been initiated under Act 2 of 1894. Is there any authority you want to submit that by this provision, then which provision will apply? Because he has relied upon a judgment of another division bench where it has been
I have come up
directed for initiation of proceedings.
I have come up with
24 of the Act 30 of 2013.
I have come up with the another division bench judgment where I had the occasion to appear before the honorable single bench as amicus curiae, where Mr. Devan Bera as well as Mr. Rai had appeared as amicus curiae. And that particular matter went up to the honorable division bench. And honorable division bench has accepted our submission and discarded the submission of State of West Bengal. I am also supplying that judgment. This is their judgment, Mohadev Khan.
Yes.
Here state took the point that Section 3(1) requisition, thereafter 4(1)(a) under Act 2, in pursuant to subsection 2 of Section 4, land got vested. Once it is vested, it remains vested. There is no provision for divesting. But we argued, the Advocate General was appearing on behalf before the single bench. The Advocate General was appearing on behalf of the state, but we took the point, no, because the Section 3 is the requisition notification. Thereafter, Section 4(1)(a) is the notice. If notice lapses, then entire building goes.
Vesting goes.
So if the inception goes, That is the inception. Notice
That is the argument of Mr. Pan.
absolutely. That was my argument before the single bench also. And this judgment, my lord, kindly see, the honorable division bench has accepted that argument. So it is against me.
Yes. Paragraph number?
Now, my lord, kindly come to
40.
paragraph. No, let me, my lord, let me place the facts, my lord. This is an appeal against the judgment and order dated September 5, 2018, whereby the writ petition of the respondents herein being WP number such and such was disposed of by the learned single judge. In effect, the learned single judge directed the state to pay compensation to the respondents, writ petitioners, under the provisions of the Right to Fair Compensation and Transparency 2013 Act for utilizing the land of the respondents, writ petitioners for construction of a public road without acquiring such land following due process of law. Then, what was the fact? Section 3 of the Act 2 was issued. Then, my lord, kindly turn to the next page. Then possession was taken. Thereafter, 4(1)(a) at para 4 on 24th November 1993. My lord has got it. Thereafter, the 7(a) provision has been jotted down, noted. Then, my lord, kindly come to paragraph 7. Admittedly, no award was made within 3 years from the date of acquisition.
As in this case.
As in this case.
Very good.
This division bench has also considered Niladri Chatterjee, also considered the Indo development, that is 2020 volume 8 SCC. Now, my lord, kindly come to the submission made by the state. Kindly come straight away to paragraph 10, which is at page 10, 11.
Page 5.
Page 5. Onwards.
Just a minute, sir.
No, I'm afraid, my lord, kindly come from page paragraph 12, page 6. Being aggrieved, the state respondents in the writ petition have come up by way of this appeal. Then,
just a minute, sir. Paragraph?
Para 12 at page 6.
Yes, para 12.
Being aggrieved, the state respondents in the writ petition have come up by way of this appeal. My lord has got it.
Yes, sir.
Then, para 13 onwards, learned advocate for the appellant submitted that the effect of incorporation of section 93B into the 1894 Act is that even if the life of 1948 Act came to an end on March 31st, 1997, the notice published under section 4(1)(a) of the 48 Act survived and the collector could proceed with the acquisition proceeding under section 93B of the 1894 Act. He submitted that issuance of notice under section 93B of the 1894 Act would mean vesting of the land in the state, since it would be deemed that the provisions of section 455A, 6, 7, 8 and 16 of the 1894 Act have been complied with. This Mr. Pan has substantially submitted distinction between 93A and 93B of the Honorable Supreme Court. Then Satyendra Prasad Jain was relied. Then Indo Development Authority versus Manohar Lal was relied. This judgment is 5-judge bench judgment of presided by Justice Arun Mishra, that I am referring 2028 volume SCC 129. Their interplay between section 24 and the acquisition proceedings started under Act 1 was dealt with. Then, my lord, State of West Bengal versus Shobita Mondol, that has special bench judgment, 2011, volume 3, CHN Cal 5555, my lord. Mr. Pan has extensively, my lord, argued, placed this matter. Then, my lord, state took the point of section 6 of the General Clauses Act, kindly turn to the next page. Try to argue that this judgment is per incuriam. Shobita Mondol, full bench judgment was per incuriam, which is at page paragraph 16. Manoj has got it. Then, my lord, the binding effect of another coordinate bench judgment.
Council that submitted the observation of the Sobita Mandol to the in respect of notice student association for if no award is made within 1 year was per incuriam. Yes.
Then, my lord, kindly come to paragraph 17. That is another coordinate bench has passed in similar types of cases. This is Shaktipada Saha. Let me hand up that as well. Saha Chaudhuri. There also another honorable division bench said, no, you will not get 2013 compensation at the
Respondent for the respondent state. Your matter will be taken up immediately thereafter.
Then, my lord, kindly come to paragraph 18. The sixth submission made by learned advocate for the appellants was that section 6 of the General Clauses Act applies in the facts and circumstances of this case, and therefore the inevitable conclusion is that what is applicable to the various procedures to be undertaken for computation of compensation are those prescribed under 1894 Act up to the stage of determination of compensation. It was finally submitted that the present writ petition ought to have been dismissed by the learned judge on the ground of laches and delay. Then, well, a reply was given by the learned advocate on behalf of the writ petitioner. Then Ganesh Samanto, my lord, kindly come to the next page, page 9. Para 21, learned advocate submitted that there is 21 is apparent difference between section 11A of 1894 Act and section 7A of 1948 Act if an award is not made within the time limit prescribed by section 7A of 1948 Act. The notice under section 41A of the said Act shall lapse. If the vesting is a conditional one and is not of enduring nature, it cannot be protected after lapse of such notice. By virtue of section 41A of the 1948 Act, possession is not taken as the possession is already with the state under an order of requisition. Therefore, the moment the notice of acquisition lapsed, possession of the land did not revert back to the owner. It would automatically revive the order of requisition, and there was no fetter on the part of the state to issue a fresh notice of acquisition under section 41A of 1948 Act and publish an award within the time limit indicated in section 7A of the Act. Now the position has changed as the 48 Act has met with its natural death and stands effaced. Even after the notice under section 41A of the 48 Act lapsed, the state could have proceeded under section 93A of the 1894 Act, as no time limit is provided for invocation of such provision. However, now that the 1894 Act stands repealed with effect from January 1, 2014, that avenue is also not open to the state. Learned advocate also referred to the decision of a division bench of this court, that is the Ganesh Samanto. My lord was referring whether Ganesh Samanto. This judgment has considered Ganesh Samanto, Niladri Chatterjee, Indore Development, everything. Now, when the notice lapsed, we cannot hold that the title which was vested with the state by operation of law under section 4(1)(a) of the said act will continue to remain with the state, even after the state respondent failed to publish the award under section 7(a) of this act within the statutory period. Then implication of section 6 of the General Clauses Act, whether in respect of temporary act, what would be the implication of section 6 of the General Clauses Act? In between, kindly come in that paragraph. If a temporary act is repealed before it has operated through the entire time period, section 6 of the General Clauses Act may apply, but not so when the temporary act runs its full tenure and meets with natural death. The moment a temporary act expires, the proceedings initiated thereunder cannot be continued unless there is express provision which saves those proceedings. Now, my lord, kindly straight away come to this next page is dealing with the laches delay on the part of the writ petitioner. Tukaram, that is page number 11.
Yes.
Paragraph 24. This entire, all these judgments are on delay and laches. Then, my lord, kindly straight away come to paragraph 27 onwards. That is the discussion. Reasoning given by the Honorable Division Bench. Page 12. To start with, a brief discussion on the 1948 Act may be helpful. The object for which the Act was promulgated will appear from the preamble of the Act, which reads as follows: an Act to provide for the requisition and speedy acquisition of land for certain purposes, whereas it is expedient to provide for the requisition and speedy acquisition of land for the purposes of maintaining supplies and services essential to the life of the community, increasing employment opportunities for the people by establishing commercial estates and industrial estates in different areas. I'm skipping over. Then, Manat, kindly come to para 28. 48 Act provided only for requisition of land. There was no provision in the Act for acquiring such requisition land. Section 3(1) of the Act empowered the state government to requisition any land if the state government was of the opinion that it was necessary to do so for maintaining supplies and services for the purposes in the preamble. Then, my lord, kindly come to paragraph 29. 4(1). Then 4(1) was quoted. Then 4(1)(a) was quoted. Then 4(2). Then, my lord, kindly come to para 30. Section 7 of the 1948 Act provided for determination of the compensation amount by the collector to be paid to the persons interested in the land acquired under Section 4. Initially, there was no time period prescribed in the 48 Act within which the collector was required to make an award under subsection 7(2) of the Act. By the West Bengal Land Requisition Amendment Act 1996, 7(a) has been set out. 7(a) was inserted and then 7(a) was set out. Then 31st March 1997, the natural death has taken place of this 48 Act. Then 9(3)(a) and 9(3)(b) was mentioned. Now, my lord, kindly come to para 16 at page 16. Thus, the effect of the aforesaid Amendment Act of 1996 was that if any notice under subsection 1(a) of section 4, which had already been issued before March 31st, 1992, and the collector had failed to pass any award thereon by March 31st, 1995, those notices would lapse. Whereas, in respect of the notices issued after March 31, 1992, the award must be passed within 3 years from the date of publication of the notice under subsection 1(a) of section 4, with the further stipulation that in default of passing of award within the time limit mentioned above, those notifications under subsection 1(a) of section 4 issued would lapse.
As in this case.
As in this case. Now, my lord, kindly come to para 37. Even after the notice under section 41A of 48 Act lapsed, the government could have revived the acquisition proceedings by serving notice under section 93A of the 1894 Act. No time period was prescribed for service of such notice. However, that was not done during the lifetime of the 1894 Act. That is also the that could
Like
not be
like the present case.
present case. That could not be done any further after January 1, 2014, the date with effect from which the 1894 Act stood repealed. The suggestion of the learned advocate for the state that even after repeal of the 1894 Act, in the present case, proceedings could continue under that act, is completely unacceptable. Such scenario is contemplated only under section 24(1)(b) of the 13 Act, which is to the effect that in any case of land acquisition proceedings initiated under the 1894 Act where an award under section 11 of the said Act has been made, then such proceedings shall continue under the provisions of that Act as if that Act has not been repealed. In the present case, admittedly, no award was ever made. In any event, section 24 of the 13 Act would not apply since the acquisition proceedings were not initiated under the 1894 Act. Myself and Mr. Pan had appeared in one matter, that is Anup Kumar Mondol, where the Honorable Division Bench has passed an order. Section 4 had taken place, Section 6 had taken place under Act 1. Then award was also made before 1st January 2014. In that case, what would be the award? Award was after 1st January 2014. How that can be said is a valid award?
Because in the meantime,
that
Act of 2013 has come into effect.
That Act 1 was repealed. Well, in that matter, my lord, ultimately, Honorable Supreme Court has upheld that yes, calculation will take place under 2013 Act, and we had calculated under keeping in the mind of 2013 Act. So this is that scenario, my lord.
In the present case, admittedly, no award was ever made. In any event, Section 24 of 2013 Act would not apply since the acquisition proceedings were not initiated under the 1894 Act. Then what will happen?
My lord, kindly, sorry.
In the present case,
yes.
Reading the last line of paragraph number 37.
Yes.
In the present case, admittedly, no award was ever made. Just like in our case, present case rather. In any event, Section 24 of 2000 Act would not apply since the acquisition proceedings were not initiated under 1894 Act.
Absolutely.
Here it is under the 1948 Act.
This 24 Act is talking about
1894 Act.
Yes. So if Act 1 is not there, if Act 2 is not there, and the land which was acquired under Act 2.
How it has been answered, that I intend to know.
I'll come to that.
Yes.
If there is both the acts are no more there, nor even Act 1, nor even Act 2, and the proceedings which had initiated under Act 2 got lapsed, then whatever is the prevailing law, that will attract. Hence, Act 2013 will attract. Not in terms of Section 24.
Notwithstanding anything contained in this Act, in case of a land acquisition initiated under the Land Acquisition Act 1994, where no award under Section 11 of the Land Acquisition Act has been made, there is a previous Act.
Yes.
Then all provisions of the relating to determination of the compensation apply.
Yes.
Or where an award under Section 11 has been made, then such proceedings shall continue under the provisions of the said land acquisition as if the said Act has not repealed. Now the two.
saving, my lord, kindly hold on for a
24
24 is saving that land acquisition proceedings which had initiated under Act 1. Kindly read that particular line, sentence.
A or B? B.
B.
Where an award under section 11 has been made. 11 means 11 of the
1894.
Then such proceedings shall continue under the provisions of the said Land Acquisition Act as if the said act has not been repeated.
Yes, saving that land acquisition proceedings.
But admit
so that the authority can continue with that land acquisition proceeding.
there is also a rider.
Yes.
Subsection 2. Notwithstanding anything contained in subsection 1, in case of land acquisition proceeding initiated under the Act 1 of 1894, where an award under section 11 has been made 5 years or more prior to the commencement of this act, but physical possession of the land has not been taken or the compensation has not been paid, the said proceedings shall be deemed to have lapsed, and the appropriate government, if it so chooses, shall initiate the proceeding of such land acquisition afresh in accordance with the provisions of this act, provided that where an award has been made and compensation in respect of a majority of the land has been, there is different thing.
That is different thing. Here, the word is either possession or award is made. So whether this or would be treated as conjunctively or either of any of those conditions, this has been answered by the Honorable Supreme Court while passing the judgment of Indore Development, that is 2020 volume 8 SCC. But this case, this has got nothing to do with section 24.
Then how it will be proceeded?
Yes, that's what I'm saying. Malad, if Act 1 is no more there, Act 2 is no more there, there is no valid acquisition proceedings except Act 2013. If the acquisition proceedings which had started in this case.
Mr. Dhar, I'm sorry. I believe principally we agree that in respect of an acquisition proceeding, because of the non-publication of the award, the vesting lapsed. Because the notice lapsed, vesting lapsed. No award was passed. Principally agreed, we have agreed, you have agreed to that effect. Now, fact remains that you have also agreed that the land is still in occupation of the state and it has been materially used by the respondent state. Then what will be the course of action? According to Mr. Pan, the provisions of the Act 30 of 2013 will apply. Then what is your contention?
In my humble submission, I do agree with the submission made by Mr. Pan. I say the same thing. Section 24 of Act 13 will not be applicable. But since there is no acquisition, state does not have any other option but to invoke what is the present acquisition law in force, that is Act 2013. Not Section 24. Section 24 is saving the...
24 is contemplating a provision, contemplating an acquisition proceeding as has been initiated under 1894.
Yes.
But according to you, since at present the only prevailing law is this, so the state has to initiate a proceeding afresh under the Act of 2013. This is your contention. What has been held here?
Same thing.
Kindly so.
Now, Honor, kindly come to. I'm not placing 39, 40. Para 48. In view of the aforesaid, the present appeal fails. We direct the first land acquisition collector, the competent authority, to initiate proceedings for acquiring the land of the appellants under the provisions of the 2013 Act and complete such proceedings within 4 months from date and pay the compensation amount to the respondents, writ petitioners within 4 weeks thereafter. না এটা দিয়ে দিলাম, এটাতে সবকটা জাজমেন্ট কনসিডার করেছে। Act 13টায় এখান থেকে বার করো না।
Mr. Dhar, I have understood your contention.
But
Actually,
I'll have to submit other few things.
I will. But section 24, subsection 2, though it is not relevant for our, it also says that the appropriate government, if it so chooses, shall initiate the proceeding of such land acquisition affairs in accordance with the provisions of this act.
Yes.
Practically, it is of the same effect. Anyway.
Now, the state of West Bengal has a policy, that is land purchase policy. Well, I should submit all this, otherwise I'll be in trouble. My client will say that
just give me a second.
I have not brought it before my lord. Now, before I do that, the another coordinate division bench judgment where state of West Bengal has এটা দিন সবই আপনার ওটা দেবে কোথায় দিয়ে তুমি শান্তি করে করে ছেড়ে দেবে
Yes.
This is another coordinate bench, sorry, Honorable Division Bench judgment. Justice Banerjee sitting with Justice Rai Chattopadhyay. I would say, this judgment has not discussed like Mohadev Khan has discussed. But here, ultimately, (2013) Act, the Honorable Division Bench has held the 2013 Act would be applicable.
Paragraph.
Well, kindly straight away come to para 12.
13.
As regards the other ground, there is no doubt that the state must compensate the respondents before us for having utilized their land, albat for a public purpose. This, in my opinion, the state must do by acquiring the land in question in terms of the provisions of 2013 Act. That is the only statute that is in force presently regarding acquisition of land from private persons. As I submitted, my lord, if that means that the state has to pay higher compensation compared to what its liability would have been under the 1894 Act, the state has only itself to blame. It is shocking that in spite of having taken over the land of the respondents several years back, not a penny has been paid to them to compensate them for depriving them for valuable property. I see no infirmity in the judgment and order under appeal. The appellant shall initiate proceedings under the 2013 Act for acquiring the concerned land of which the writ petitioners are still the owners. Such proceedings shall be completed within 12 weeks from the date of the communication of this order to the competent authority in the administration, the compensation in terms of the 13 Act shall be paid to the respondents within a month thereafter. So both these judgments, I would say Mahadev Khan is betterly reasons are betterly explained.
Yes.
Now, my lord, again, another division bench.
No, if the same principle is
No, not same, not same. This one is again against Mr. Pan.
Not sure.
So I should place all the judgments. এটা আবার Justice Orijit Banerjee sitting with Krishna Rao.
Oh, Baba. This has been discussed and my lord, in that another matter I was appointed as amicus curiae. So my lord, that judgment I can place if we may place this judgment and open court. Justice Banerjee opined that we were wrong in passing this judgment. This was opined in the open court.
But I'll have to place. My lord, since the division bench judgment, kind Shoktipodo Saha Chaudhary, Bhul judgment. My lord, in Mahadev Khan, this judgment has been discussed, but the author of the judgment are same in both the matters, and my lord, Justice Banerjee has accepted this analogy later on. This Mahadev Khan judgment is passed on 22nd December. আমি কি explain করে দিচ্ছি 22nd December 2023. My lord has got it. And this Shoktipodo Saha Chaudhary judgment is on 12th April 2022. What has got it? Both the judgments.
The previous judgment.
This Shoktipodo is the previous judgment. Where the Honorable Division Bench has held, no, the land loser will get the compensation at the old rate, which cannot be. Well, in my humble
Anyway,
submission,
this judgment will prevail.
yes,
This judgment
yes,
will prevail.
Mahadev Khan will prevail.
I will not take that.
এটা বলে দিতে হয়, আমি তো সবকটাই বলবো।
Very good. Then
Well, as I said, that I will get the flex from my clients and from others. Well, I must submit that there is another policy of the government that is called land purchase policy. And in several matters,
land purchase policy.
yes,
Has that policy any overriding effect of the 2013 Act? That is to be considered.
I'm afraid no.
Then
But I should bring it to before my lord. My job is done, then at least nobody can blame me that.
you have not argued all the points.
Yes,
You see, here,
already.
government may take a policy, but whether that policy is has an overriding effect of the Act 30 of 2013, then it may be irrelevant. Otherwise, it is not relevant. So that's all, Mr. Adhar.
Well, I also bring it to before my lord that this argument was advanced by the state of West Bengal before the Honorable Supreme Court in one matter. And in that matter, the Honorable Supreme Court has reprimanded the state of West Bengal for taking the plea that there is no rules to implement the Act 2013. And finally,
the rules have been
finally, from one of the district of state of West Bengal has issued notification under 2013 Act.
Notification under
Yes.
That means?
That means the fresh land acquisition proceedings had started under Act 2013.
I understand.
Well, this is all.
Asho, take down. Um,
It has been handed over to your lordship.
Sir, I have noted something from that. Keep it. You will get it within very short time. I do not keep any my judgment pending for a consideration.
I know. Obliged.
এই শোনো শোনো এই বইগুলো সব একসাথে রাখো এইটাও রাখতে হবে। খাম এনেছিলাম না যাবো তো ওদেরকে খাম ছিল তোর সাথে এরকম একটা গ্রিন কালারের খাম ছিল সেটা কি হল ওই ফাইলের সঙ্গে তো রাখা ছিল
কি জর্জ পরের ম্যাটার তো হবে না
তাই গেল সে করে নিচ্ছে না
your argument on the last occasion.
No, I have not concluded.
You have not concluded.
I have
What more you have left? Everything you have concluded. You have showed the report of the estate manager. You have showed that how the authority has relied upon the report of the estate manager.
Facts I have pleaded.
But prior to that, what I'm asking
Yes, one
that
question, my lord.
instead of availing the appellate provisions under section 18C of the NEB property of 1960, why file the writ petition?
Yes, that I answer. That I will answer. That will come from the division bench order, single bench, concurrent bench order itself.
this honorable court, I will show to your lordship, single bench has said that it cannot be treated as a section 18 application, because if had it been a section 18 application, then limitation would apply. That's why, my lord, single bench has specifically said that it cannot be treated under section 18 dispute.
Why?
That's lordship.
It is not a section 18 dispute.
Yes, that is the finding of the, based on which the proceeding has been initiated before the authority on the basis of an order of the earlier order that I should place before lordship.
So,
if your lordship kindly turn to order at this particular proceeding initiated based on page 65 is the order of single bench.
just a minute, sir. It is WPA 240379. Yes, Mr. Roy.
Just I am placing, Lord. First of all, my submission would be the proceeding.
Page number?
Page number 65. Actually, one problem is that there is, in the absence of marking at 2 p.m., other side is also not here. Anyway, Lord, I am submitting.
Mr. Dey is appearing, no?
Yes,
Only,
I am for the state testimony.
there is one.
Sorry?
I am for the state
State,
testimony.
enemy property also there. Anyway, my lord, 65, page 65.
Please take your seat, sir.
Yes, ma'am.
Page 65.
Yes.
This application under Article 226 of the Constitution of India impeaches the vesting of land stated to be that of the petitioners by a notification dated September 10, 1965. At the outset, it must be recorded that despite two opportunities, the respondent did not file an affidavit in opposition, though served. Therefore, even though I was waiting with eagerness to hear Mr. Dasgupta, learned advocate on the facts on behalf of the central government, unfortunately, I am restrained by procedural law from doing so. We will have to proceed on the basis of the pleadings contained in the writ petition as if they were gospel truth. From the writ petition, it appears that the petitioner is a transferee of a citizen of India property. He claims that as citizen, this property would never have been recorded as an enemy property. His further submission is that his property does not figure in the schedule. His last submission is that no copy of any order under Section 7 of the Act was ever served on him, nor was given any opportunity to contest any proceeding in which the property was declared to be enemy property. He submits that he had no notice or knowledge of so-called declaration of this property as enemy property before attempting to get the land mutated in his name, when the revenue officer concerned mentioned that it was not possible to mutate the property in his name, since it was recorded as an enemy property. It was only then that he made a request under the provisions of the Right to Information Act 2005, and the assistant custodian of enemy property by letter dated December 8, 2018, informed him that the land had vested in the central government by notification of September 10, 1965. In this petition, he has challenged the said notification. The contention that a citizen, his property could never have been treated as enemy property, and or that his transferor having been a citizen of India, the property could never have been treated to be an enemy property, proceeds on the basis of provisions of the Enemy Property Act 1960. 2017. Before such amendment, the definition of enemy of clause 2b excluded a citizen of India. On that basis, several judgments of the Honorable Supreme Court had been rendered, which had clearly laid down the law that definition of enemy provided under Section 2b excludes citizen of India as an enemy or enemy subject or enemy firm. One of the judgments cited in this behalf is case of Union of India, another versus Raja Muhammad Amir Muhammad Khan reported in year 2005 Supreme Court 38840. Thereafter, in 2017, Act 3 of 2007 made a sea change to the definition of enemy under the Section 2B of the Act with retrospective effect from January 7, 2016. Section 2B reads as follows. 2B. Enemy or enemy subject or enemy firm means a person or country who or which was an enemy subject, including his legal heir and successor, whether or not a citizen of India or a citizen of a country which is not an enemy, or the enemy subject, or his legal heir and successor who has changed his nationality, or an enemy firm, including its succeeding firm, whether or not partners or members of such succeeding firm are citizen of India or the citizen of a country which is not an enemy, or such firm which has changed its nationality, as the case may be, under the Defence of India Act 1962 and the Defence of India Rules 1962, or the Defence of India Act 1971 and the Defence of India Rules 1971, but does not include a citizen of India other than those citizens of India being the legal heir and successor of the enemy or enemy subject or enemy firm. It could have been argued that since the retrospective effect was with from January 7, 2016, the petitioner who purchased the property on December 30, 1998 from his vendor who had purchased the property in 1973 pursuant to a transfer made to him as vendor in 1953, when all of them are citizens of India, the property could not be enemy property. Unfortunately, the amended Act of 2017, the enemy property.
Mr. Rai, you straightway come to page number 71 of the of your writ petition. Straightway come.
Before that,
no, you said straightway come first.
71.
However, first paragraph, however it appears.
However, it appears from the record that the petitioner made a representation
on November 8, 2018 to
the respondent authorities, but no response has been made thereto by the authorities. AIR 2005 to Supreme Court 3483, being the case of Raja Muhammad Supra itself, records the concerned court that dangerous attitude resulting in doing the institution damage which is developing, that justice is required to be done only the courts. This attitude is betrayal of constitution as well as laws. Every and any authority working under the statute has to discharge its duties in a just manner, otherwise people will lose faith in government. In such view of the matter, regardless of limitation, the representation of the petition must be considered and disposed of in accordance with law, and keeping in mind that the case of the petition and the transferee or citizen of India, not enemy, has not been controverted, cannot be disputed in the eye of law. In view of the fact, no affidavit in opposition was filed. However, if the respondents have records with which are unimpeachable, which shows otherwise, the respondent to has been entitled to take a decision in accordance with law, even if it is against the interest of the petitioner. The entire exercise must be completed within a period of 2 months from the date of communication of.
So, by the practically while disposing the judgment, the limitation period of 30 days, as has been prescribed under Section 18 of the Enemy Property Act 1968, has been condoned. So practically an order has been passed under the Enemy Property Act Section 18 of the. So why are not preferred appeal?
Page 70 of the judgment. I start from this. In view of in such view of the matter, despite taking the statement contained in the petition as true and correct, I cannot for the first instance take a decision as to whether the property be the enemy property, nor can I all fairness ask the petitioner to approach the forum under Section 18 of the Act to redress his grievance, because in doing so, the order of vesting must be first served on the petitioner so that he can make a representation. And it is no longer open to the respondent to dispute that no such copy of the order was served with the petitioner. If I say the petitioner to approach the authority under Section 8, there will be a question of limitation. Therefore, my lord, in substance, this is not not taken as in Section 18. If lordship kindly says it. Court is saying so, I cannot take it as section 18. Court is saying it is an representation. And that should be considered. And the proceeding has been initiated.
No, if that be the so, then why the court has come to a finding that in such view of the matter, regardless of the limitation, the representation of the petitioner must be considered and disposed of in accordance with law.
But first sentence starts with that. As a page 17, lordship, kindly read it. In such view of the matter.
What is your representation? Where is your representation before? Where is your representation?
Page 73.
Page 73.
No. Sorry, my lord.
I believe we have prayed for
page 50, my lord.
Page 50.
Page 50.
Now you have prayed for setting aside the recall of the decision of vesting.
Yes.
With a further prayer to record your name in the record of right.
Yes.
Now what section 18 says? The central government may, on receipt of a representation from a person aggrieved by an order vesting a property and enemy property in the custodian of within a period of 30 days from the date of receipt of such order or from the date of publication in the official gazette, whichever is earlier, and after giving an reasonable opportunity of being heard, if it is of the opinion that any property vested in the custodian under this act and remaining with him was not at enemy property, it may by general or special order direct the custodian that such property vested as enemy property in the custodian may be transferred to the person from whom such property was acquired and vested in the custodian.
Therefore,
so we have practically prayed relief under section 18.
No, my lord. What I say, my lord, to squarely come on the section 18, to squarely come
No,
on
Mr. What I propose, without hearing Mr. D, I am asking the department to treat this writ petition as an appeal. And to place the
appeal, they are saying appeal before the High Court.
Yes.
According to them,
yes,
the High Court, which is the forum?
There must be some forum. There must be some forum.
In High Court.
No, if I direct the department to treat this as an appeal and allow you to revise or present a fresh presentation form, and the period which has been exercised for proceeding with the instant writ petition, the period has already lapsed for the exercise of the writ petition will be excluded from the point of limitation. The appeal court will take care of this writ petition as an appeal.
But I have no objection in it. If lordship holds it, then it has to be by the division bench. I don't mind, because everything is there. It can be heard. Facts remain, my lord. Within time it has been. So much 226, my lord, is within time as stipulated in 18(6). 60 days. That is there. There is no problem in it. If you lordship relegate to a division bench for his disposal, I don't mind. I have no problem.
Practically, the prayer.
Problem is when we do not place all the facts before your lordship, it will not be possible for your lordship to come to a proper decision. Stand today has been taken that before the single bench said that it will not be under section 18, you dispose of the representation. Then they filed a contempt. Mr. Rai has been harping about the contempt every other time, but now he has skipped it. Before the contempt, before the contempt, we made the representation. If your lordship kindly say page 89. We said second paragraph, my lord.
Hmm.
It is submitted on behalf of the alleged contemnor, that Shri Sanjeev Sehgal, Joint Secretary, FFR Department, Ministry of Home, is the authority to deal with the case for the petitioner. That means he is the authority under section 18. Now, my lord, kindly come to page 92. After this order is passed in the contempt, he did not raise this point that it cannot be treated under an application under 18. He files a representation file, kindly see 92. Representation filed under 18, section 18 of the, so he has waived that order, my lord. Benefit of that order.
Sorry, I failed to understand. But
My lord, Mr. Rai's contention is that appeal is, he need not file an appeal because it was supposed to be a representation, not an application under section 18. That is his contention. Therefore, I have no need of appeal. My contention is that the correctly pointed out, single bench has said that it will not be an application under 18. I agree to that. Now, during the contempt proceeding, we pointed out before the honorable court that it should be before the authority. Who is the authority under section 18? Yes.
Where is the finding? He is
Then-
authority under section 18?
Then my lord, kindly see.
Where it is said?
Then my lord, can you see 92? This is not
92.
my 92. It is not my petition.
92 is a written statement.
Kindly see the from the top. F number 37, etc. Representation filed under section 90 and 18 of the enemy.
This is a representation of custodian anybody. They are written submission.
No, sir. What do you want to say?
Which one?
This one, you read it.
So,
Sir, as
this,
a matter
this
of
objection is
fact-
not taken.
As a matter of fact, Mr. Rai's client has sought for some relief under section 80.
Yes.
Basically, his relief is
Basically.
under section 80.
So he has to prefer an appeal.
The coordinate bench has considering the case, has
time.
exempted the period of limitation.
Yes.
And practically, I believe that an order has been passed under section 18 of the Act.
80.
So when the instant writ petition has been filed within the period of limitation, and when the earlier coordinate bench has allowed you to consider this application without going through the point of limitation. So what is the predicament in converting the instant writ petition as an appeal?
I have no objection.
Very good.
I have no objection.
But only thing, my lord, the point, there is another thing. Because
Every fact is before.
I do not, I will not, I don't know, one fact was not before, not there before the single bench. And a fraud on the court was committed.
No, it will be treated as an order passed under section 80.
I am making a submission which I have not got. I am making a submission which is till date, not made.
In dealing with order 43, my lord, I have dealt with. And my lord, when says procedural part, I have said I have not find anything that this type of appeal can be preferred. Rule also doesn't say so. My lord, delegate it. I will do it.
My lord, only one thing. The order before the learned single bench, previous order, was obtained by fraud.
Very good. That will be decided by the division bench. Fraud or all these things.
Because they were in possession of
appeal, everything will be open.
Yes.
they have been paying rent.
Yes.
These matters may be kept open, my lord. Points of law, maintainability may be kept on road.
What
maintainability, sir? Appeal,
my lord.
Appeal court will take care of
all the pleadings is there. We will urge all these things.
This cannot. Ashwin. The
Normally,
First appeal always division bench.
but it is a miscellaneous appeal. It will be a miscellaneous appeal. Normally, and I have gone through, my lord, it is not within 96, order 43. Order 43.
No.
Special
Yes.
act. Special act, but it should be a misappeal.
No, these are only for academic knowledge.
Yes, I have gone through, my lord. I have also come across the civil procedure code. I did not find anything.
No, it is an appeal under the special statute.
Special statute. That's called misappeal. Otherwise, it cannot be. No degree has been.
Order 40, it will not come under order 41.
Yes. I have come across, I am reading, my lord, for the
Very
last
good.
5 days.
Because
I just put a question.
this is very important because I have come across an appeal under the chartered account reference that came up before a division bench. Motor vehicle accidents are usually taken up before single bench. So there, these are all statutory appeals, my lord. So there is a dichotomy. We'll have to find out what.
No, to be very honest, I am. In time, I have also gone through so that I can come to a logical conclusion after hearing you all.
I was reading 96. I was reading order 41, but I don't find any. Even the rule doesn't prescribe.
Statutory appeal
Before the High Court, only says
everybody is happy.
I was telling Mr. Rai that he should have withdrawn and filed afresh. That would have helped him, my lord. DC will get only appearance fees. He will not get any.
what would happen to me, I know.
No, it's all right. Thank you very much. Yes, call the next matter. কত নম্বর আইটেম? এই কি আমি শুনেছি নাকি? তপন কুমার, মিস্টার তপন কুমার গুপ্তন। কোনোদিনই থাকছেন না। ও, ইট ইজ দ্যাট ম্যাটার। রিজার্ভ ব্যাংক অফ ইন্ডিয়াকে ডিরেকশন দেওয়া হয়েছিল। রিজার্ভ ব্যাংক অফ ইন্ডিয়া অ্যাপিয়ারও করেছিলেন তো। The parties are not represented today.
My lord, Mr. Prantik was appearing for the petitioner, my lord. He is on his legs, my lord, before the.
Then why have asked me to fix it as specially fixed
My
matter?
lord, it was fixed, my lord, on the last
Not
occasion.
today, not
Yeah.
today.
I'm good.
I appeal to the petitioner.
Within 10 minutes, it can be disposed of.
No, it will take.
With your other side.
Mr. Ghosh raised.
Then I'm making it not today. Within 10 minutes, it cannot be disposed of.
Cannot be disposed of within 10 minutes, but
Because he has raised a point that during the pending.
Very good. I'm making it not today. It will remain in the list. Come on the next week. 69 not today.
70 also, these two are identical.
Identical not. Now give the application. Call the application matters. It can be taken up.
Mala, I am for the petitioner led by Ms. Devjani Sengupta. This is the affidavit of service.
কি আছে দেখি দাও
My lord, my lord, this is a restoration application, my lord.
let the file be placed first. Can 4.
Yes, my lord.
What's your good name, madam?
Poulomi Ghosh.
Poulomi Ghosh.
My lord, this is a restoration application, my lord. The writ petition was dismissed for default on 28th.
Within time.
Within time, my lord.
What is the reason for your non-appearance?
My lord, when the matter was called on, my lord, the advocate or the petitioner could not appear, my lord. Upon noticing from the display board, my lord, that the matter has been called on, my lord.
In which paragraph it has been stated,
my
madam?
lord, paragraph number 13.
1-3.
1-3.
Although learned advocate made no mistake in keeping a watch over the matter, on 28 April 2025, the instant writ petition was called for an hearing, and the learned advocate for the writ was not aware of the same. What does it mean? Huh? Upon noticing from the display board the matter has been called on, immediately last hour came to the matter. What do you want to say?
My lord, we are keeping watching the matter, my lord, but when the matter was called on, my lord, we could not appear before this honorable court, my lord.
So what is the good of keeping watching?
My lord, they are specifically not mentioned when the matter was called, my lord.
In each case, it will be mentioned at 2:10, 2:15, 2:05, this way.
My lord's order is at page 11
Yes, my
of
lord.
this application, my lord. On the day before, on 7th April also, none represented for the petitioner. As my lord was pleased to note.
Very good. হ্যাঁ রিট পিটিশনটা কোথায়? এ তো সব ক্যান দেখছি। এইগুলো কি তাহলে? কি তাহলে এ তো রিকনস্ট্রাকশন হয়েছে মনে হচ্ছে তো। যে করে না এরা কিছু বুঝতে পারি না।
না না রিকনস্টিটিউটেড না, আমি সার্টিফাইড কপি অবটেন করেছিলাম। In my lord's order dated 24th January this year, my lord was pleased to record that it is further submitted on behalf of the writ petitioner that the affidavits in reply against the affidavit in opposition as filed by the respondent number 3 and 4 are misplaced.
Order number?
Order number, serial number 7, order dated 24th January this year, my lord's order.
24th
January this year. On
মহা মুশকিল হলো। Learn an advocate for the writ petitioner press for an accommodation to file fresh affidavit in reply after reaffirmation. That has been filed.
Yes, my lord. 10th March of 2025, my lord, we have filed.
10th?
10th March of 2025.
my lord, in the order, on your lordship's order dated 10th March, the observation regarding writ petition was at the last page, at page 6. It was a liberty granted to the bank respondent to file exception to their supplementary affidavit. And the exception has also been filed, and that has been taken on record on 20th March.
এ করলেন এবং আমি তো কিছু বুঝতেই পারছি না কোথায় রিট পিটিশনটা তো তৈরি হয়েছে এটা বুঝতে পারা যাচ্ছে। এটা তো রিকনস্ট্রাকশনটা হয়েছে, তাহলে এফিডেভিট ইন অপোজিশনটা কোথায়? এর মধ্যেই আছে নাকি? না এটা তো
My lord, the affidavit in opposition was filed long back on 1st November 2000.
এটা সাপ্লিমেন্টারি এফিডেভিট হলো। এগুলো ক্যান গুলো সরাও দেখি, ক্যান গুলো আর লাগবে না, সব ডিসপোজ অফ ক্যান গুলো অন্য ফাইলে রাখো। রেস্টোরেশন অ্যাপ্লিকেশন বকুলতনামা তো আছে, এফিডেভিট অফ সার্ভিস হলো, এটা হচ্ছে রিট পিটিশনের, এটা সাপ্লিমেন্টারি এফিডেভিট হলো, তাহলে এফিডেভিট ইন অপোজিশনটা পাওয়া গেছে। ইয়েস, এফিডেভিট না, এটা তো অ্যাপ্লিকেশন ফর কন্ডোনেশন অফ ডিলে এফিডেভিট অফ। Affidavit in opposition has been filed.
Yes, my lord. The affidavit in opposition was filed and that has been taken on record by the then my lord Justice D.K. Sheth.
The order sheet গুলোও নেই, report দিয়েছে।
My lord, this is the photocopy of the certified copy of the order sheet whereby the affidavit in opposition was taken on record.
It would the affidavit in opposition in connection with an can.
My lord, this was the affidavit.
Have you filed your affidavit in reply?
Yes, my lord, I have filed in relating to original writ petition and also relating to CAN application.
Forget about can. Cans are disposed of.
Yes, my lord.
কি লিখলাম, the pleadings are complete. However, on careful perusal, no, however, it is reported by the SEO that the affidavit in opposition against the writ petition in your appearance slip, give your mobile number to them. তোমরাও দেখে নাও যদি এটা অ্যাভেলেবল হয়। আর এই শোনো, এই ক্যান এবং ক্যানের কানেকশনে যত এফিডেভিট অপোজিশন গুলো আছে সব আলাদা করুন।
Certified copy of the affidavit in opposition from the department, and I have obtained it on 21st January this year.
That is not
Affidavit
there.
in opposition of the respondents.
That is not there.
Reply also there.
Respondent bank.
Respondent bank.
It is your transport brief.
1998, my lord.
You are
And the
not at all
affidavit in
diligent,
opposition.
madam. Many a times it has been dismissed. Again, you are restoring unnecessarily. Your client is still alive, I believe,
Yes, my lord.
with an expectation that he will get a justice.
Yes, my lord.
But your attitude does not show it, which is why the matter are getting dismissed for default for a considerable length of time. On a number of occasions, it has been dismissed.
And the affidavit
You are
in
not at all
opposition was of year 2000, my
This
lord.
is the change brief, my lord, and last.
Let me do it.